Mr. Johnson, I think we were still trying to get you connected when I let Mr. Shoemaker know. We are going to, your item is number 3 on our agenda, so I'm just going to ask that you mute your line and turn your camera off until we get to that time.
Yes, ma'am, I can do that.
Thank you so much.
All right, good morning, everyone. It's Thursday, November 18th, 2021, and this is the regular meeting of the California Fair Political Practices Commission. Ms. Linker, would you please call the roll?
Commissioner Baker? Here. Commissioner Cardenas? Commissioner Wilson?
Here.
Commissioner Wood?
Here.
Chair Matich?
Here. To item number 1, this is public comment for items not on today's agenda. Do we have any public comment on the phone? Items not on today's agenda.
Yes, I'm Steve Petzold.
Morning, Mr. Petzold.
Hey, it's nice to be back with you. Just wanted to give you public comment. I wondered whether there was any money offered by the commission for people like me that actually follow these campaigns and make complaints, which involve fines. During the past year, I've had, I believe, 6, probably worth at least $30,000. This involves a substantial amount of time, and I have to personally travel to Norwalk to be able to pull up the records for these campaigns, since the information is not on. So if there isn't a reward money program, I think that maybe the commission should look into putting one in. I'm also interested in requiring in the future newspaper publication of the stipulations or reference to them in newspapers of record in the area where the violations are committed. I found that many newspapers are reluctant to publish negative information about public agencies within their jurisdiction because they rely on those agencies for money. So there's no public shaming of these institutions. College of the Canyons, Glendale Community College, Antelope Valley College, etc. So I believe that as part of the stipulation, you should require the individuals or organizations to purchase space in a newspaper of record and publish the stipulation so that the public knows what's going on out there behind this. I'd also like to see a minimum payment for your streamlined settlements. I believe that some of these involve people that are rather sophisticated, but they're dismissed saying, hey, well, they really don't, they just didn't know the regulations, and no harm, no foul. I believe that if you put in time and you find that a complaint is valid, that there should be a minimum settlement amount of $500 to $1,000. I'm also concerned that case 2017-00998 against Michelle Jenkins, it's been a long time. This is a 4-year complaint, has been open, and I think that the staff should pay attention to that, and I'd like to see a resolution to that particular case. Thank you.
Thank you, Mr. Petzold. Do we have any additional public comment for items not on today's agenda? Hearing and seeing none, we'll proceed to item 2. That's approval of the Commission's meeting minutes from our October 2021 regular meeting. I had one point of clarification in the minutes that I wanted to have Mr. Bainbridge address for us. On page 2, the second full paragraph, there is a sentence that says, Commissioner Baker asked if the structure of the proposed regulation, which I will represent was the behested payment regulation we adopted last month, will require office holder to have constructive knowledge that there's a staff member involved. Ms. Harrison confirmed that to be true. That, after reading that, my question, Mr. Bainbridge, is can you clarify whether or not that in fact is an accurate statement? My understanding was under the regulation and the language, we required actual knowledge.
Yeah, I think the minutes themselves, it looks like this is on the middle of page 2, accurately reflect what was said. I think that was a misstatement about the applicability of 18424. It doesn't have a constructive notice provision. Constructive notice is a very specific legal term that is not in the regulation. So I don't think it's accurate to say that constructive notice is sufficient as the reg is drafted and how it was adopted.
All right. So for our purposes today, because the minutes accurately reflect the exchange that occurred, we would approve the minutes, unless there are other edits, we'd approve the minutes as submitted, but then create a record through these meeting minutes that that statement was in fact,
Yeah, I think that's the appropriate way to handle it.
okay. Do other commissioners have edits or comments to the meeting minutes?
Thank you for noting that, and I just want to point out that I agree, and that was the point of my question, was to make it clear, and originally, and I'm glad that we're kind of putting something on the record now that is not assuming constructive knowledge in the the only other one that I had, and I don't know that it would be an edit or if it would just be noted in these minutes, is at the page 8, the sentence before item 9, I had inquired about, there were questions about the recall process, and we had just been through a recall process, and we had been talking about kind of getting an analysis somewhere along the road from probably your team, Mr. Bainbridge, on what are some things that we learned about how that worked out for us and impacted us. The sense, as Mr. Bainbridge stated, this topic is on everyone's radar. My understanding is, in terms of what that means and what I recall from our meeting, is that we may have a report on that in the future, perhaps as we have a fuller complement of commissioners, so we can kind of look back and see what we learned. I just, for purposes of today's minutes, wanted to confirm that is what it means that it's going to be on, it's on everyone's radar, means that we're going to, at some point in the future, get an update on that. Is that correct?
Yeah, I don't remember exactly what I said, but that the way you've said it is true. It's an issue we're looking at, and we're going to come back to the commission, probably in the form of a proposed regulatory action in January.
Wonderful. Thank you. I appreciate that.
Any other commissioners have edits or comments on the meeting minutes? Hearing and seeing none, do we have a motion to approve?
So moved.
Second.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Ms. Linker, do we have Commissioner Cardenas yet? All right. Mr. Lau, before you get settled at the table, I think I'm reluctant to go into the administrative adjudication without Commissioner Cardenas. I know he's having some technical difficulties this morning. So perhaps what we can do is instead move to, we'll skip items 3 and 4 for a moment and move to the enforcement consent calendar. Chief Brereton. I know.
Good morning.
Good morning.
First, I would like to pull from the consent calendar item number 7, County of Stanislaus.
Remaining items are 5, 6, and 8.
Correct.
All right. Did any commissioners wish to pull any of the remaining items for separate discussion from?
I'd like to pull item number 6, the matter, please.
Any other commissioners wish to pull matters for separate discussion from the consent? All right, so the only item that we're pulling is item 6. The consent calendar consists of items 5 and 8 for today. Ms. Brereton, Chief Brereton, did you have any comments for us on either of those items before we proceed to?
I would just like to point out that we brought the Barry Chang matter back as requested by the commission. We followed the commission's direction, and we included the information that was requested, and negotiated with the other side, and are presenting this new stipulation to you with that information.
Right. Any commissioner comments or discussion on the consent calendar? Hearing and seeing none, do we have a motion? So moved on the consent calendar.
Second.
Any public comment on the consent calendar?
Oh, Tom.
Item 8.
Item 8, go ahead.
Yes, this is Steve Petzold. I filed the complaint in the matter of Lundgren Management Corporation. Obviously, I haven't been party to any knowledge about how this negotiated with the party. I will say that this particular Lundgren Management gave the bulk of their money after the election was already known. They made two $30,000 contributions after the election date. I felt like there had been a deal between them and the committee to fund the shortage and deficit that the committee had received. Lundgren Management received a construction management contract for a new science building in Canyon Country, California, before this even went to the ballot. And so they were guaranteed a large multi-million-dollar construction management. I know that you are only allowed to enforce the Fair Political Practices Act. I do believe that this indicates that there's a pay-to-play scheme for Lundgren Management. One of the employees of Lundgren Management on the board of the foundation also gave money. So one of the penalty is really insignificant, millions of dollars that this company contributed to the campaign. I feel like the penalty should be at the maximum level. So that's my feeling, and I will turn it back over to you.
Any additional public comment on the enforcement consent calendar?
Yes, please. My name's Eugene Solomon. A procedural question, please.
Please.
I have comment on an item within the executive staff report, a stipulated agreement. Would that be made here, or would that be made under item 16 when the executive staff report comes up?
That would be made under item 16 when the executive staff report comes up. Right now, we are only referring to items 5 and 8 on the enforcement consent calendar.
Thank you, sir. I'll wait.
Thank you. Any further public comment on enforcement consent calendar? And seeing none, Ms. Linker, please call the roll.
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. We'll now proceed for our separate discussion of item 6 in the matter of Charles Grace. Commissioner Baker, you pulled the item.
Thank you. Just briefly, thank you for updating the language regarding public harm. That was very helpful. My question goes to a relatively minor point. At the top of page 10, we had, last meeting, as we discussed this, really wanted to push the need for there to be training on the issue. I appreciate that that is there. It mentions that the course is required by AB 1234. Just wanted to confirm that that training does include conflicts of interest and 1090, these exact type of situations that the respondent found himself in.
Yes.
It's unclear from the step.
Yes,
Okay.
it does.
Thank you. I think that's important to do, and I appreciate that being part of this. I just wanted to make that point of clarification. Thank you.
Chief Brereton, I actually have a separate question for you on the Charles Grace stip. On page 3, footnote 8, This refers to the legal effect of our approval or adoption of this stipulated agreement as administrative. And last month, when we considered this stipulation, it was my understanding that as a matter of law, when we approved the stipulation, the contract at issue would be voidable, but it would be void. This footnote suggests that that's an open question of law. And so I just wanted to know from you, can you clarify, is it an open question? And if so, what, if anything, are we doing to bring clarity to that area of the law?
Thank you. I jumped the gun a bit last month when I said that the contract would be void as a matter of law. It is unclear. This is the very first time that an administrative action has been brought under 1090. So it has not been determined yet whether that provision of 1090 applies under administrative actions. So, you know, we have some ideas about how we could pursue determining whether or not it would apply. Probably what we would need to do would be to take our approved stipulation to a court, a civil court, and request a declaratory order that the contract is void. We're not, there's no precedent for this. This has never happened before, so, you know, it would take some putting some heads together and figuring out, like, how do we make this happen, if that's a course that the commission wanted to explore. We can also leave it up to the parties to, you know, determine that they want to void the contract after such a stipulation has been issued, the parties to the original contract, I mean. I would note there, in this particular situation, since Mr. Grace was not an elected official, he was not a voting member of this body. The rules are, the 1090 rules are different as applied to him. He is allowed to contract with the district. It's the way that he went about doing it that is the problem under 1090. So as long as it is clear that he is not involved in his role as an employee or contractor of the district, then he can do that. So that's something to keep in mind for this particular issue. It's a little bit different than if it were a person who is an elected member of the body voting on the matter.
So if, under these circumstances, if instead of in the context that we have today where it's an administrative action, this was being adjudicated in a civil action and it was found to be a violation of 1090, under these facts, would the contract have been void as a matter of law by a finding that 1090 had been violated?
I believe it would. I think if we were to bring a civil action under 1090 as the enforcement division, we would request that finding specifically in our pleadings. You know, we would, so that it would be clear that is part of the relief that we're seeking. But like I said, this is the first time that we have brought anything under 1090. We're bringing this under our administrative authority, so we just don't have answers to all of these questions just yet.
Right, and I appreciate that. I think, to my mind at least, I think it's important that we get the answers. Because we are, as you point out, we now have this authority, we have exercised our authority for the first time, and it's unclear what the legal effect of us doing that would be. I think it's important for the commission to have a full appreciation of what the legal effect of our actions are. And so, unless I have any my colleagues, I'd ask that you come back to us, you know, in maybe a month or so, with some information on what our options are and what the research has shown in this area. Because again, I think it's new authority that we have, and I think it's very important that we understand what the legal effect of our decisions are.
No disagreement.
I would, oh, Commissioner Baker, would you? No. Yeah, I would totally agree that this is a matter that's very serious, and the allegations are serious. So I think the chair's recommendation makes total sense.
I can probably get something to you by January, but with the December meeting coming up, I won't have the bandwidth to deal with that right away.
I was thinking January too.
Okay.
I hear you're a little busy. All right.
Mr. Chair?
Thank you,
Sorry.
Chief Brereton. Commissioner.
Thank you. For time purposes, looking into what happens here does not affect, I guess I'm asking, this stipulation and its binding nature. I mean, there is a footnote here mentioning something is unclear. This stipulation doesn't affect our ability to go forward should we choose to pursue a declaratory action. I guess I'm asking it as a leading question, but do you have any information on that?
I think we would need the stipulation in order to pursue any type of declaratory relief regarding whether the contract is void. So, I don't remember exactly how you phrased your question, but so I believe we need this, an approved stipulation in order to move forward.
As the first step, okay.
Yes.
And are you aware of any, I guess you can look into this and let us know in January, just be looking at any statute of limitations that might be in place for seeking a declaratory action. Since the stipulation would have just been entered, I imagine the clock starts ticking very recently, but I don't know that, so that's always an important thing to look into. I'm sure you do that. Thank you.
Any other questions for Chief Brereton on item 6? Hearing and seeing none, do we have a motion? I will move approval.
Second.
Sorry, I just need a clarification. Are you
Commissioner
moving,
Wood, please.
sorry, are you moving approval with this footnote as is?
Yes.
Okay,
Right. We have a motion. We've now called for public comment.
Hi, I'm April, and I have public comments on this item.
Yes, please.
First off, I appreciate for taking this as, yes, Abby, why are you? I'm confused. Abby's raising her hand. I don't know if you guys can hear me or what's going on.
We can hear you. You are on public comment on item 6. You have 3 minutes of public comment time.
Okay. Thank you for recognizing the importance and severity of this issue in particular. I realize that there really is no precedent for it, and that you guys have now in your ability to create a precedent for it. You have FPPC rules in place on purpose for a very good reason, and Mr. Grace did not follow those. So the fact that people will write in and say, Mr. Grace is a good guy, or he's doing the best he can, that's not the issue at hand. The issue at hand is, did he follow FPPC rules? And he did not. So I really hope that you take that into consideration when you make your decision. If this contract issue is a loophole in your rulings, then now's a great time to close that loophole and use this as an example. And because otherwise you're showing that this loophole is a way for people to get away with the very things that Charles Grace is getting away with, which he doesn't deserve to get away with. He has affected the District of San Simeon for hundreds of thousands of dollars at this point. This little part in front of you at the FPP, minute drop in the bucket, is deleterious existence in San Simeon. So please do everything within your power to sanction and get this man out of what he's doing.
Thank you. Do we have any additional public comment on item 6? Hearing and seeing none, Ms. Linker, would you please call the roll?
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
aye.
Chair Matich?
Aye.
The motion passes.
Thank you. All right, now we'll return back to item 3. Thank you, Chief Brereton. We'll now return to item 3, and this is our administrative adjudication, and we'll begin with oral argument. This is in the matter of Lloyd A. Johnson for West Covina City Council 2015, Lloyd Johnson and John Shoemaker. And this is case number 2076. Morning, Mr. Lau.
Good morning.
Did you have any opening comments that you wish to make before we proceed with the oral argument?
I guess I should just state that, most of our discussion will take place in closed session. This is really pursuant to commission regulations. The parties have requested it, oral arguments which are permitted under our regulations, so we can proceed with that.
All right, thank you. So in terms of scheduling and process here, there are a total of 2 respondents in this case, Mr. Johnson, Mr. Shoemaker. Each will be afforded 5 minutes of oral argument time, and the Enforcement Division will have 5 minutes to present their case with respect to each respondent. Enforcement can reserve up to 2 minutes of those 5 for rebuttal time. We'll begin with Enforcement's presentation regarding Respondent Johnson.
Good morning, can you hear me?
Ms. Gilbertson. Mr. Johnson, you will proceed with your argument after Enforcement Division. So just hold tight, sir.
Yes, thank you.
All right, Ms. Gilbertson, good morning.
Good morning. I'd like to reserve 2 minutes for rebuttal. Good morning, Chair, Commissioners. My name is Teresa Gilbertson, Senior Commission Counsel for the Enforcement Division. I present to you today a proposed decision in the matter of the accusation against Lloyd A. Johnson for West Covina City Council 2015, Lloyd Johnson and John Shoemaker. In 2015, Lloyd Johnson ran for a seat on the West Covina City Council. During his campaign, John Shoemaker served briefly as a treasurer and throughout this election cycle served as an agent for the committee. Shoemaker assisted Johnson with the campaign strategy. He made expenditures on behalf of the campaign, including procuring mass mailings, yard signs, robocalls, and more. The law requires that mass mailings include a true and complete sender identification in order to assist voters in determining who is responsible for political spending and advertisements. The law further requires that the committee fully report activity, including expenditures, in-kind contributions, and activity that supports or opposes other candidates. The law provides that an expenditure made by an agent of a committee is presumed to be coordinated with the benefited. During the campaign, Shoemaker caused 2 mass mailings to be distributed to potential voters. These mass mailings were negative pieces encouraging voters to vote against other city council candidates. These negative mailings included a fake sender identification, including a fake committee name and purporting to have a mailing address at a mailbox center. This was in violation of Government Code 84305. Additionally, the committee and Johnson failed to report this political activity on campaign statements in violation of Government Code 84211. The proposed decision finds that Johnson and his committee are liable for 2 counts of failing to report political activity and 2 counts of failing to include a true and correct sender identification on mass mailings. The proposed decision states findings of facts that are supported by and consistent with the evidence and contains an accurate statement and application of law. The total penalty of $9,000 for the 4 counts is appropriate, and the decision reasonably weighs the factors in Regulation 18361.5. The Enforcement Division therefore recommends that the Commission adopt the proposed decision and penalty, but also make technical and minor changes as discussed in the brief submitted. Thank you.
Now proceed to Respondent Johnson. Your opposition argument, sir, you have 5 minutes.
Yes, can you hear me okay? Hello?
Yes.
Okay, first of all, I'd just like to say about these negative hit pieces, I knew nothing about them. I don't know if you can see this this picture I'm gonna try to hold up. There's a few pictures here of me with one of the people that was on the negative hit piece, Tony Wu. Tony Wu and I were actually campaigning for each other. So that shows I had nothing to do with it. And I also have, if I may, give me 1 second here.
Sir,
I have
we're
an
bound by
email.
the information before us. We're not permitted to take additional photographic evidence in this proceeding.
Oh, you're not? Okay, like I say, I do, one of the gentlemen that when I was out campaigning, he, asked me who else I should vote for. And in his email, I told him I would recommend Tony Wu because he is a businessman. And him and I were campaigning for each other. So I'd just like to say, I knew nothing about these emails that were sent, I mean, these, hit pieces that were sent out. And the only first time I found out about them is when they were brought up to me. So I just like to say I'm 100% innocent on this. And I'd like to hold a minute or two to say something at the end, so that's okay.
Nope, you have 5 minutes of opposition argument, sir, and then we conclude with enforcement's rebuttal. You do have remaining time, so you may continue now if you wish.
Oh, like I say, it's everything that went on without my knowledge. I took over my campaign in September of, as my own Shoemaker was a friend of mine. He still is. But what he did, he put out his money. He ordered all these other things for me, my watch list, my phone list, and some signs and everything else before he was off as my treasurer. So I'm in a meeting right now. Ordered them for me. I felt it was my responsibility to pay him because he ordered them. We did the same thing. John Shoemaker was my treasurer in 2013 when we ran our campaign. We ran a nice, clean campaign.
Here's we've lost Mr. Paul as well. We try to get him back.
Can you still hear me now?
You dropped off for a second there, sir, so you may want to restate whatever you just said.
I just action there for a minute.
Sorry, you're breaking up. Sir.
Even though I ended up losing my 2 votes, and I knew nothing about any hit pieces. So I just want to throw myself out there telling you I had nothing to do with this, and I would hope you would take that into consideration. Thank you.
Thank you, sir. Appreciate your argument. Gilbertson, you have 2 minutes of rebuttal.
Respondent Johnson argues that he was ignorant of Mr. Shoemaker's actions. Unfortunately, this would not be a sufficient defense in this matter. Agency was found in this case and is supported by the evidence. Though Johnson and Shoemaker attempted to make the appearance that Shoemaker had left his committee by removing Mr. Shoemaker as the treasurer, the proposed decision finds that there is significant evidence that Shoemaker continued to have a role in Johnson's campaign. Mr. Johnson trusted Mr. Shoemaker, delegated authority to make expenditures, reimbursed Mr. Shoemaker without receipts, and relied on Shoemaker's knowledge, connections, and even his bulk mail permit to send other mailings. Mr. Johnson paid Mr. Shoemaker just prior to the election for this work for mailings, a robocall, and more, without any receipts or invoices to substantiate the payment amount. The proposed decision does not make a finding as to Johnson's knowledge because it was not necessary. Mr. Johnson is liable for the actions of his entrusted agent. He relied on Shoemaker to assist him with this campaign. Therefore, as previously stated, the Enforcement Division supports the proposed decision with the recommendation that we make minor and technical changes. Thank you.
Thank you, Ms. Gilbertson. Now proceed to Enforcement Division's case in chief with regard to Respondent Shoemaker. Ms. Gilbertson, you have 5 minutes with regard to those claims. Do you wish to reserve any time for rebuttal?
I will reserve 2 minutes for rebuttal. I am here to present the proposed decision as it relates to John Shoemaker, an agent for the Johnson Committee and Lloyd Johnson. Government Code Section 84305 requires that all mass mailings include a sender identification. This allows for the public to identify the committee responsible for the mailing. The proposed decision makes findings that Respondent John Shoemaker is liable, along with the committee and Lloyd Johnson, for failing to include true and complete sender identification on 2 mass mailings that were distributed in 2015 in connection with the West Covina City Council race. As stated, during the campaign, Shoemaker was found to be an agent of the committee. He acted on behalf of Johnson and the committee, negotiating deals at the printer, designing and producing advertisement content, including door hangers, yard signs, and pro-Johnson mass mailings. He arranged for the distribution of mailings and robocalls, and he received payment for these services. At the same time, Shoemaker caused 2 mass mailings to be distributed to potential voters. These mailings, the subject of this case, he hired a printer to print these that he had designed. He used his bulk mail permit to pay for postage. These mass mailings were negative pieces, encouraging voters to vote against other candidates for city council. They included a fake sender identification, meaning that they purported to be sent by a committee that did not exist, and included an address to an unaffiliated mail center. This was in violation of Government Code 84305. The proposed decision states findings of facts that are supported by and consistent with the evidence, and it contains an accurate statement and application of the law. The total penalty of $6,000 for the 2 counts against Shoemaker is appropriate, and the decision reasonably weighs the factors in Regulation 18361.5. Therefore, the recommendation is that the commission adopt the proposed decision and penalty, but also make technical and minor changes as discussed in the brief submitted. Thank you.
All right, Mr. Shoemaker, you have 5 minutes of time to make your opposition argument, sir. You're on mute, Mr. Shoemaker. Please unmute before you begin your argument.
Sorry about that. This case is simple. The investigators came to a decision and a conclusion before gathering all the information, did not and would not investigate anything that deviated from that conclusion. When asked why Lloyd Johnson was involved in the case, investigator number 2 said, because he was the only person in the campaign not to have a negative mailer sent out against him. He was completely unaware there were 6 candidates, not 5. Thus, another candidate did not have a negative mailer sent out on them either. When the information was given as to who paid, the following happened per emails, conversations, documents, and testimony. 1, told not to investigate, move on. 2, a phone call to the campaign manager when informed. 3, a phone call to the campaign manager after the probable cause hearing 4 years later. Reviewed the campaign filings, and there's nothing to show they were involved. Isn't that why we're here not reporting? 5, did not investigate because the person came in last. 5 different explanations for the failure to investigate the information given to them and who paid. Lloyd Johnson and I have given 5 different reasons to be off with our heads. Why was Lloyd Johnson considered involved? I was associated with this campaign at one time. So the 2 other campaigns I was associated with had to report? No, different offices. So the activities investigators claim are wrong are okay as long as it involves different offices. Makes no sense logically or legally. The investigators claim the official relationship continued because of emails and payments. Now the investigators claim when a technologically challenged man who's been a friend for 25 years asks, can you send the files to the printer since you have them, is now illegal. I am reimbursed for expenses incurred earlier, is now illegal. We would now be here for exceeding campaign contribution limits if he had not. I sent his already prepared mailers to the printer, which he picked up, paid, and mailed. Also, the investigators themselves show no money came from Lloyd Johnson to pay for any of the costs associated with the mailers, have shown no knowledge and have no testimony he was involved. Only testimony he was not. Vendors. I was paid and reported the income on my taxes. Was the person associated with another candidate or just an overzealous supporter? We will never know because the investigators failed and refused to investigate. At best, they made a phone call. No interviews, no subpoenas, no demand for records, emails, or anything. As a vendor, I have absolutely no obligation under the law to report to the FPPC. Just as the printer did not have to report, just as the sign maker did not have to report, just as the campaign consultant did not have to report, just as I do not have to report for other campaigns which I was working, nor did I have to report for each of them or Lloyd's. 2 of my activities for others were for the same office, yet the claim reporting was required for city council, not the school boards. all three campaigned together. The following explains the whole process, which is now completed its 6th year. The original investigator testified this was a nothing case which should have gone away quickly. Another investigator stated he had not seen this type of case take almost 6 years to get resolved. As the counsel for the committee stated when things dragged on, we are busy with other more important matters. One wonders why it took so long, and the investigators were always asking for the maximum penalties for a nothing case that should have gone away quickly. It is because at least one investigator on social media bragged about the amount of money they had collected. Is this about money? The counsel for the FPPC gave us both the option of walking if we told on the other. So give one guilty party a pass to get the other. That is a tactic our criminal justice system is trying to eliminate. Sounds to me money over justice. In summary, the investigators have shown no agreement, discussions, or knowledge Lloyd Johnson was involved. To punish a person because he knew the parties involved opens up liabilities in the area that is unjust to the public, was never intended by the section of the law used to make the connection. Also, the investigators are trying to put reporting requirements on vendors, which is unprecedented in this act. Not only are they trying to make dubious connections, but the investigators have said only the parties are running for the same office. As the original investigator stated, this is a nothing case which should have gone away quickly. The committee should agree with that sentiment. At a minimum, reduce the draconian fines to a minimum more fitting a nothing case, not important enough to press forward, or in the interest of justice, dismiss the case. It opens a Pandora's box of future campaigns while making it legal to cheat using the investigator's logic. Thank you.
Gilbertson, you have 2 minutes of rebuttal.
The law provides, as I've previously stated, that an expenditure by an agent for a committee, it's presumed to be coordinated with the committee that benefits. During our investigation, Mr. Shoemaker flatly denied being involved. He was uncooperative and unresponsive to questions about his involvement. And only when he was presented with evidence did he admit his involvement. He then claimed that his actions were at the behest of a third party. However, he failed to produce any credible evidence to support this claim. As stated in the proposed decision, Shoemaker's, quote, representations that this client materialized at a city council meeting and that their dealings all occurred in person and in cash are not credible, end quote. The proposed decision finds that the respondents coordinated to benefit Johnson in his city council race. The content of this mass mailing at issue was of Mr. Shoemaker's own design and intention. He hired vendors to carry out this work at his direction. He was hired as a treasurer and a political consultant. He knew the requirements for sender identification. He caused several pro-Johnson mass mailings to be distributed that did include the correct sender identification. The act holds that any person who violates the act or who purposefully or negligently causes any other person to violate is also liable. The evidence supports a finding that Shoemaker caused the violation by creating and distributing these mass mailings. Therefore, as previously stated, the Enforcement Division supports the proposed decision, but recommends minor and technical changes. Thank you.
Thank you, Ms. Gilbertson. That concludes our oral argument in this matter. The commission will now adjourn into closed session to deliberate on this matter.
Hello? All right, we're back on the record following our closed session deliberations on the administrative adjudication in the matter of Lloyd A. Johnson for West Covina City Council, 2015, Lloyd Johnson and John Shoemaker. The commission has determined that we will adopt the ALJ's proposed decision with the following modifications. First, that we will include in the decision the recommended technical non-substantive changes from the Enforcement Division. Secondly, with respect to counts 1 and 2, we will reduce the proposed penalties from $1,500 each to $1,000 each for counts 1 and 2. Otherwise, the remainder of the decision is we will now move to item 9. This is the first of our general items, and this is adoption of proposed regulatory changes permitting the use of secure electronic signatures. With us today is Commission Counsel Kevin Cornwall. Morning.
Good morning, Chair Matich and Commissioners. Today, staff is recommending the Commission adopt the proposed regulations relating to the use of secure electronic signatures, with pre-notice discussion having occurred at the September Commission meeting. The Commission has previously expressed a policy objective of modernizing its interpretation of the Act's filing requirements, and recent legislation, particularly statutes related to the Cal Access Replacement System, has shared this goal and aim to increase filing in electronic format. Today's proposed regulations would help achieve this goal by modernizing our interpretation of original documents to include a greater number of electronic submissions. This is particularly important during the ongoing pandemic. As the Commission is aware, last year, based on prior interpretations of the Act, the Commission had to advise Form 700 filers without access to electronic filing systems to mail their Form 700s rather than submit them in person in order to limit their risk of exposure to COVID-19. Currently, documents can generally be submitted in one of two ways: physically filing paper documents, or, if available, via an electronic filing system. Electronic filing systems have the benefit of being largely automated and more transparent than paper filings. A large number of state agencies, counties, and cities already have electronic filing systems in place, so officials in those jurisdictions already have a method of filing documents in electronic format. However, in jurisdictions that have no electronic filing system, the only option officials have had is paper filing. The proposed regulations and amendments would bridge this gap and establish a third option, an alternative that would allow for submitting certain documents in electronic format where no electronic filing system is available. Proposed Regulation 18104 would specify that an original document includes those created in paper format with handwritten signatures, as well as those created in electronic format with a secure electronic signature. We would define secure electronic signature in two ways. First, a secure electronic signature would include signatures entered via an electronic filing system, so there would be no additional requirements or substantive change for jurisdictions that already use an electronic filing system. Second, a secure electronic signature would also include filings submitted in electronic format via agency email where the filings include a digital signature. As discussed in the memo, a digital signature essentially acts as a digital fingerprint that not only helps ensure the identity of the signer, but also ensures that no changes have been made to a document after signing. Proposed Regulation 18757 would similarly specify that this alternate form of submitting Form 700s would only be available where, one, the filer does not already have access to a certified electronic filing system, and two, the agency has chosen to permit that method of submission. This language was included to ensure agencies are receiving electronic submissions in a uniform manner and have assessed their ability and readiness to receive Form 700s through a new method. Regulation 18757 would also require the Form 700 with a secure electronic signature to be emailed from the official's agency email address as an additional security measure. The proposed amendments to Regulations 18115, 115.2, and 723.1 would update these regulations to better reflect proposed Regulations 18104 and 757 and clarify how filing officers are to handle statements submitted through this new method. We have received feedback and support from several agencies, and in some instances, we also received recommendations on preferred or alternative language for some of the provisions. We greatly appreciate all of the feedback and recommendations from the regulated community and considered all of the comments we received. As noted in the memo, with respect to campaign filings submitted in paper to the Secretary of State, we think that given the relevant statutory language, the best way of addressing this would be via legislation rather than regulation. We also considered the feedback we received from the UC system, which essentially advocated for an either-or approach to electronic submission methods. That is, adopting a system in which officials could submit documents with digital signatures via agency email, even if they already have access to an electronic filing system. Again, we appreciate this feedback and understand that there could be some benefits to this approach, but ultimately we recommend against it in favor of the language that we presented to the Commission for several reasons. First, the UC system discussed the value of comparing the efficiency of an electronic filing system versus digital signatures to determine which is obsolete, viable, or in need of improvement. However, the UC system can dictate whether a particular university has access to an electronic filing system, so that comparison would still be possible under the proposed regulations. Second, we had discussed this approach internally prior to the pre-notice discussion at the September meeting, and after getting feedback from our SEI unit, we ultimately decided to go with the approach recommended today. Our SEI unit emphasized the desire to have more filers submit their document via electronic filing system, and we don't want to deter officials from using a system they already have access to. Although we believe that the use of digital signatures is sufficiently secure and a viable submission method, we also believe that electronic filing systems are the best approach, particularly because they offer the greatest amount of transparency to the public. We want to continue to encourage officials to use electronic filing systems where available. Finally, and just to reiterate, the regulations proposed today were intended to help bridge the gap and ensure some method of electronic filing is available to every jurisdiction, particularly during this uncertain period where physical filing may be impractical. If some officials have an uncertainty with respect to an electronic filing system already available to them, providing those officials with additional training materials would be the preferable solution. With that, staff recommends the Commission adopt the proposed regulations, and I'd be happy to answer any questions the Commission may have.
Thank you, Mr. Cornwall. Do any commissioners have questions for Mr. Cornwall? Commissioner Baker?
I do. Thank you, Mr. Cornwall. I appreciate it. Mine go to the comments from UC and the statement where they said the proposed regulation prohibits that kind of exploration and development. I'm just reading their letter in the middle there. And I think what I'm hearing from you is you think it can happen. Can you drill down a little bit more on, it sounds like you disagree with what they're saying, that the regulation doesn't prohibit the type of, quote, exploration and development that they think it does, because I was persuaded by their letter, but it sounds like you weren't. I just like to know a little bit more why you think the regulation does allow them to do what they think they can't do.
So thank you for the question. In drafting the regulation, we had to take into mind all of the various jurisdictions that the regulation would apply to, and the UC system is a bit unique just in the structure of it. But given that there are different universities, the university or the UC system could, for example, say that UCX, they could set up an electronic filing system for that university. It sounds like they already have that. Or they could get rid of the electronic filing system for UCY and compare things that way, if that was something that they wanted to pursue. However, again, we don't want to deter any agency from using an electronic filing system that they already have, particularly because electronic filing systems offer greater transparency to the public.
Can I jump in and ask you a follow-up question there, Mr. Cornwall? And that
Yes.
is, you use the example where the UC, they already have an electronic filing system. They could designate a campus to try the signature method as opposed to the electronic filing system. But my reading of the reg is they could be far more granular than that. They could select a small group of filers at a particular campus and allow them to test out whether or not the electronic submission of signatures was a preferable approach, so that they could determine which way they want to go. Is that also permissible, or does it have to be an entire campus that would switch over for testing purposes?
Dave may have more details on this, but yes, I agree with your reading of it that in general, jurisdictions have the ability to say who has access to an electronic filing system. So you're correct that it doesn't necessarily have to be a, all or none approach. But yeah, if General Counsel Bainbridge has anything he wants to add to that.
Yeah, I think that's correct. The way the reg is written is does the filer have access to this filing system? Ultimately, it's up to each jurisdiction on whether to have a filing system or not. It's not mandatory. They're allowed to have a filing system which their filers are permitted to use. So my reading of the reg, and if I had an advice request based on this, would be if that system isn't available to that filer, then they can use this other means of filing the statement. And the agency is essentially in control of what modes of filing are available to their employees.
All right, so going back to Commissioner Baker's original question, we believe that this regulation does afford the flexibility that UC is concerned about.
Yeah, I think it does. I understand their concerns, but I think based on the answer I gave that that would satisfy their concerns, that they could try out these other methods and still be within the language of the regulation as proposed.
Thank you. I appreciate that. It might be my residual, I was vice chair of higher education, and every time we put an imposition on UC or a rule or regulation, anything we could do to remove inefficiencies and make it easier for them to save money and get things done was always good. So when I saw this, I thought, gosh, are we making sure that they do have the flexibility they think they need? What I'm hearing is it might be a good idea for them to get an advice letter that once these are adopted, if they are, that could give them additional guidance and information on it. And I've got no problem with that, so thank you.
Any other questions or comments on item 9 from commissioners?
Just kind of a technical question, I guess, for Mr. Bainbridge. General Counsel Bainbridge, when would these regulations take effect if they were in fact adopted?
Unless we set a different date, it would be the standard 30 days from when they get sent over to SOS to be processed. So probably a month and a half from now, I would estimate. Or we can set, we're getting near the end of the year, so maybe, if you want to, in the motion, have them adopted effective January 1, 2022, that might make sense.
Yeah, all right, I would defer to the chair. I'm just kind of raising that question, so thank you.
Yeah, the general rule is they go into effect once all the paperwork's processed, but we can always set a different date for them to become effective.
Thank you.
Commissioner Wood, I think you had your hand up.
Yeah, I was just wondering if you could just spell out a little bit more for us. You've said a couple of times kind of conclusively that electronic filing is more transparent than digital signatures. Can you explain why that's the case?
So electronic filing systems, in general, most jurisdictions use software like NetFile, which is largely automated, and it allows the public to essentially go on. I believe it can be affected by the settings that a particular agency uses, but the public can go on and access the public records through that system rather than have to submit a request to some individual at the agency, have that person, bring up the digital copy, or if it's a physical copy, scan and send it to them via email. Electronic filing systems in general allow for the possibility of like instantaneous access to these materials.
That's really helpful. So what you're saying is the digital signature would be basically on something like a PDF. And so that's not as easy to search, but the electronic filing system, when they're entering all the information into the system itself, that's what makes it easier to call up. Is that right?
Yeah, essentially, okay. The digital signature method it basically represents an improvement and more transparency over, say, paper filing, but we believe the best approach still is electronic filing systems.
Thank you very much for that clarification. That's really helpful.
No problem.
Any other commissioner comments, questions for Mr. Cornwall? Seeing none. Do we have any public comment on item 9?
Good morning. This is Allison Leary with the League of California Cities.
Good morning.
I just wanted to note that the League of California supports the written comments that were submitted by the University of California and would like to urge the Commission to adopt their proposed amendments to the regulations. In addition to supporting the reasoning of the University of California, we wanted to highlight that many elected and appointed officials sit on a number of different boards, each with different filing systems and software. And so allowing filers to use a digital signature, even when the FPP certified electronic filing system is available, would increase the ease with which these filers can file and therefore increase compliance and make filings more timely. Therefore, we think that the proposed changes that the University of California set forth would result in more access to the public and would further the intent of the Political Reform Act to increase transparency. Thank you.
This is Mark Moridomi I'm an attorney with the UC. May I comment?
Yes, please.
Yes, I'm an attorney with the University of California, and way back in the 20th century, I was an FPPC employee in the Enforcement and Legal Divisions. I'm glad you've read the university's comments. Regarding testing, I believe Commissioner Baker had that question. The example I'd like to raise is our UC San Diego campus that has a older FPPC certified legacy system, and their filers file with them because that particular electronic system is specific to the UC San Diego campus. So that campus would not be able to test or try out the DocuSign or the digital signature system as my reading of the regulation, as that electronic system is specific to the UC San Diego campus. We have two other campuses that have electronic signature systems, legacy FPPC certified systems that are specific to a campus. Regarding NetFile, our Form 700 filers use NetFile. I use NetFile when I file my Form 700. It is fairly complicated, and the public does not have transparency for a Form 700 that is not filed or not filed on time, and allowing our filing officers the opportunity or choice to use both a legacy filing system and electronic signatures will increase public transparency because those documents will be filed, those forms will be filed and available to them. I'm happy to answer any questions. Thank you very much.
Thank you. Yeah, any further public comment on item 9?
Yes, Mr. Chair, this is Nick Warshaw at Olson Rem Show. First, we're encouraged and thank the Commission to modernize the PRA. But we also wanted to emphasize campaign filings, just the tremendous resources that are spent in connection with filing campaigns via paper, especially during COVID. There's tremendous burden both on the Secretary of State, who has to sort and sift through and spend state resources to maintain paper records, but also during COVID has been a tremendous burden, both us as a firm, but more importantly on our clients trying to get difficulty getting FedEx or post offices during COVID has been extremely difficult and continues to be difficult. So assuming you agree with staff's conclusion that you don't have the regulatory authority to permit electronic filings for campaign reports, we strongly encourage the Commission to sponsor legislation that permits electronic filing in the campaign context and or not assess any fines or pursue enforcement actions for late paper filings, especially during the pendency of the pandemic. Thank you.
Thank you. And I would say, at least speaking for myself, I agree that getting electronic filing of campaign reports is important. That is why, as Mr. Cornwall mentioned, we evaluated first for our regulatory authority, having determined that that was not an option, that we are pursuing some legislative ideas. At appropriate time, we'll bring those back to the committee. Thank you for that comment. Any additional public comment on item 9? All right, Mr. Bainbridge, I have a question for you. You heard Mr. Morodomi's comments about he feels that the proposed regulatory language would impede their ability to test at certain campuses. Given, what's your reaction to that?
Not knowing how they're set up, it's hard to say. Our intent with this regulation, I think, is as it's drafted, it is up to the agency to determine what is available as a way of filing. If they have a system that they decide that is old and they don't want to use anymore, nothing requires them to get another electronic system or update their system. They can stop using that system and try to use the digital signature system instead. It's within their control of what sort of system they use for their filers. And another point I would point out, just to consider, we're not necessarily against this language that's been suggested. As Mr. Cornwall mentioned, this was a decision point that we worked with our own filing people on and went back and forth on whether it should be that if you have an electronic filing system, you don't accept them digitally, or if any of the three is available. And what our people said in the SCI unit is it's already difficult for them. You can't mandate electronic filing currently. You can only offer the system to your filers. People can still file on paper if they choose to. So what they have found is they really try to encourage everyone to use the electronic filing, but they can't make them. So to them, introducing one more way in which people could file documents would further complicate their jobs, processing time, that sort of thing. Because not only do they have the electronic filing and the paper filings, they're also getting digital signatures emailed to them that they then have to validate. And, you know, it just creates a record keep issue for them. So they ultimately came down on, we would prefer to have it, if electronic filing is available, there's no reason to have this digital signature because there's already a way to do it electronically. And if it's not available, then you can make it available, as opposed to potentially creating 3 different avenues for people to file. I think it's important to remember our goal here was to allow a way for electronic filing to occur when people, as an alternative to paper, as opposed to an alternative to the electronic filing systems, which do allow for electronic filing. Again, if the majority of the commission would prefer to go with that other decision, We wouldn't object to that for any reason. We just think what we've proposed is a better way, largely based on what our own filing officers have suggested to us.
Yeah, I appreciate that. I have a follow-up question on that. So the concern from the filing officers is today they get the electronic filing system and then they receive paper copies. And they're concerned that if now we allow PDF signatures, now they have a third category, right?
Right.
Did they contemplate that perhaps the number of paper filings would be reduced, corresponding with the increase in the PDF filings? And then the follow-up question is, if that is what would be anticipated to happen, is there some efficiency that's gained by processing electronic documents as opposed to having the paper?
Yeah, I didn't ask them that question. I mean, I think their assumption was less people would want to do the electronic filing if they could do the digital signature filing, because then they don't have the electronically filed documents that are immediately accessible on our website. They almost have the benefit of the old paper filings, but they have the ease and the convenience of sending in something electronically. But we could only guess until.
Right, and we could also, hypothetically, we could accept the proposed changes requested by the UC and the league. And if that becomes a burden on staff, we could return to this regulation at some point.
Sure, and we could get input from all the other agencies that are more like us, which is they receive filings from their own employees or a group of people and not a more complicated system like the UCs where they have many different campuses and 2 different types of filers that they receive from. So we could, if we did it that way, we certainly could come back for input from people in the field who are actually receiving these and see what they think.
All right. At the end of the day, though, it's the agency, like the UC, for example, that still remains. It's their call whether they allow the digital signature call, right?
Right. And that was intentional because we wanted to make sure people felt comfortable with how they were receiving the statements and they were able to process them.
Thank you for answering my questions.
Kind of a related technical question. Mr. Bainbridge, as it relates to what, Commissioner Matich just posed, is there ever been the option of adopting a regulation with a sunset date? So in other words, it's adopted and then it's only effective for a year or 2 years, which then allows the commission to revisit the issue and then, of course, continue the regulation or modify it.
Not aware of that ever happening. I think it's better to do it informally, which is we say we'll come back and look at this and rather than it going, because once we allow this, it's going to become the norm. And so if it somehow goes away and none of us are still here and they don't realize that this is sunsetting, there's going to be a lot of confusion and trouble.
Well, maybe speaking for myself, but not for you, though. You'll still be here.
Thank you, Commissioner Wilson. Commissioner Baker?
I appreciate the good questions that you've asked, Mr. Chair and Commissioner Wilson. I would move to adopt the proposed language from UC. And I don't know what the time period is, but I'd like to put in that we come back and evaluate. I don't know if it's after 18 months, what time period might be correct, but that we have an analysis of this that we know will be on the clock for at least 1 filing period, perhaps 2. That would be my motion to do that. I'm not acting too prematurely, but that's where I'd like to see us go.
I'd second that motion. Any other commissioner comments, though, before we call the roll?
Just for clarification, would that be including, you can see on the proposed language for 18757 from the UC system, bracketed language, that would be including the bracketed language if permitted by the official's agency filing officer.
Would you kindly point to which page or line, if you happen to have that in front of you?
Yeah, it is the last page of the last page, and it is line number 8. And right, so just seeking clarification on whether to include the bracketed language or not. It doesn't appear to be entirely necessary, given that the proposed language in 18104 would still include the on line 6 of page 3. It would still specify in electronic format if specified by the filing officer, but just for the sake of submitting to OAL exactly what the commission intends.
I can answer with a question, if I may answer, Mr. Chair. Can you anticipate, I don't see any reason why not to, just to make it clean. Is there any flag you are seeing in doing it that way?
No, that would be more in line with the language that we already have. So, yeah, I would recommend to include that language still.
Then I would say, yes, that is the intent of my motion, is to include exactly as UC has prepared it and submitted it to us. Thank you for pointing that out. Thank you, Mr. Chair.
Right. We have a motion. We have a second. Ms. Linker, please call the roll.
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. All right. At this point, we have a lengthy agenda today, so we are going to break for lunch. The commission will return at 1 o'clock following our lunch break. At 1.
So if anybody wants any of the treats.
All right, welcome back, everyone. We're back from our lunch break, and we'll pick up with item 10. This is adoption of the 2021-22 Statement of Economic Interest, Form 700. With us is our Assistant General Counsel, Ms. Brar. Good afternoon.
Good afternoon, Chair Matich and Commissioners. I'm here to present the 2021-2022 Statement of Economic Interest, Form 700, Form 700A, Form 700U, and Form 700 amendments for adoption. They've been updated with dates and filing deadlines, gender-neutral language, new electronic signature rules, and the expanded Statement of Economic Interest rules that were adopted by the Commission last year. In light of the UC changes that were adopted by the Commission on the last item, these documents haven't been updated with that yet, so I propose to make some edits to incorporate those changes that were adopted. And what that would entail, I can give you an example. It's the same change on all of the documents. On the Form 700, on page 3 of that document, on the top right, where the yellow highlighted language is, under how to file, it would be the 6th line down. It would be deleting when an electronic filing system is not available. And that would be the same change on the Form 700 amendments as well. And so with that, staff recommends adoption of these documents.
Ms. Brar, appreciate it. Any questions for? Do we have a public comment on item 10, the SEI forms? Hearing and seeing none, do we have a motion to approve?
Move to approve?
I can second.
All right, Commissioner Wood is second. Would you please call the roll?
Commissioner Baker?
Aye.
Commissioner Cardenet?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you.
Thank you.
Thank you, Ms. Brar. We'll now move to item 11. This is adoption of proposed regulations relating to amplification of online communication. And today, we have General Counsel, Mr. Bainbridge, sitting in for Commission.
Torrance said he refused to give this presentation one more time, that I had to do it. He actually is on vacation. Amplification is an issue that has kind of spun off from our prior regulations that were adopted a couple months ago concerning online and social media disclosure, where we were enhancing the regs to provide greater and more accurate disclosure. So this is the last piece of that. If it gets adopted today, it will be effective January 1st of 2022, like the rest of the regs that we passed I think it was last meeting or 2 meetings ago. So the purpose of this specific regulation is aimed at enhancing the disclosure around when funds are spent to artificially inflate some of the apparent online support or opposition for a particular candidate or measure. It's the practice of purchasing bots or likes or other forms of approval or disapproval through social media or other online means. So what we're looking at specifically with this regulation is this misleading practice that would tend to indicate more support or opposition for a particular social media page that a committee has than is what in reality, because they're not real people, even though they appear to be real people. That's what we're specifically aimed at here. At the pre-notice meeting, everyone will remember we had a broader definition of amplification, and there was a consensus amongst the commission and staff as well that we should narrow that definition. So this version before you now narrows that definition. And what it does is it focuses on, it's narrowed by focusing on the phrase through the purchase of followers. So previously amplification was defined more broadly, and it could be sort of a more natural way of enhancing someone's electronic footprint or their advertisement. Here we've narrowed it so that the term specifically just refers to the practice of purchasing these artificial support or opposition of some sort. So I point that out to show that we have narrowed it significantly, and we're really talking about a very small subset of activity, and that's because we wanted to hone in on this activity that was misleading in its very nature. It appears as if there's more support or opposition for something than there actually is. So that's the goal here, just kind of resetting where we were last time. So the way that we're proposing to get at this amplification would be to expand the reporting requirements for expenditures of this sort. So the Act requires a description for each expenditure of over $100 of what was paid for. Here we're just giving more context as to what that description should include. And it's specifics about that they were paid for amplification. And then there's an issue that we'll discuss later amongst the commission as to how much more information, whether we want to include the quantity of actual items purchased or just the fact that a particular form of amplification was purchased by the committee. Just to reset the commission's reasoning behind this reg and the previous regs we've considered, expenditures under the Act are required to be fully and truthfully disclosed so that voters may be fully informed. This is one of the basic tenets of the Act. And there's the buying of fake followers, the commission deemed inherently misleading, and so the commission decided there was a need for additional disclosure because of the inherently misleading nature of this particular expenditure. It's similar to the social media influencer / blogger reg that we passed a couple of months ago, where in order to really have an understanding of what's really going on, it requires a little additional disclosure. And so that's what we tried to accomplish with this regulation. This isn't unheard of in the Act. Page 3 of our memo highlights a few other areas where the Act or the Commission through regulation has required some additional information, where there is sort of a likelihood of confusion or lack of information for the voters. One example is if you pay someone to speak, to be a paid spokesperson, there's an additional requirement that you disclose them as a paid spokesperson. Without that, there'd be maybe an assumption that this celebrity or whoever did support the official, whether they do or not. We feel, or the Act feels it's important to disclose that person's identity. I see this as similar to that, where because of the nature of the communication, there's a likelihood of confusion or misinformation, and so there's some additional disclosure to hopefully combat some of that. So at pre-notice, I believe the commission had a consensus that they wanted more disclosure around this specific area where you're purchasing followers and the like. There was some debate about whether it should include the specific amount or just that it was purchased in general. So I have a few slides that we can put up that will just show the difference in the reporting. In the draft we've presented of the regulation, there's highlighted language, and depending on what the consensus of the commission is, we can either include that language or remove it. So Jesse, if you want to put the... Okay, so there's the proposed language that's before the commission. The highlighted language is what the commission will be deciding whether to include or not. Either way, the proposal would describe the amounts paid for amplification and the type purchased. So if you go ahead and go to the next slide. So this slide shows what it would look like if you included all of the language in the proposal. So you'll see it looks the same as it otherwise would, except in the description. It says, for example, online amplification, 10,000 Twitter followers, and then the amount paid. And then if you look at the next slide, this would be without that additional requirement. So it just notes that it would be online amplification, and it would be for Twitter followers without any indication of how many there would be. We can take that down. So that's the proposal at this point. I would open up to the commission to either have the discussion about the additional language, or if we want to have questions before that, do that.
Thank you, Mr. Bainbridge. Appreciate it. And before we begin, I do want to just recognize and thank Commissioner Wood for bringing this issue to the full commission's attention. It's a great example of how modern campaigns in today's times, in the modern times, are doing things very differently than the types of traditional campaign activities that the Act was originally written, at the time the Act was originally written. I mean, these lawn signs are real tangible things. They're in real people's yards with their consent. Here we are talking about a practice, and I think Mr. Bainbridge correctly characterized it as a misleading practice where somebody is paying to give an impression of greater support or opposition than is in fact really true. So Commissioner Wood, I just want to thank you for bringing that to our attention as an area for potential regulation. And I also want to thank Mr. Lewis for all of his work over the past few months with Commissioner Wood. With that, Commissioner Wood, I don't know if you wanted to start. This is, as I said, this is sort of your idea, so I wanted to defer to you to start.
Yeah, I appreciate that. I've been thinking, oh, I'm getting an echo. Thanks. I've been thinking, I've been reaching for the right analogy here because, I've talked about this in the academic setting and, legal academics when it comes to campaign finance sometimes come in with a real perspective on how much regulation should happen. And I try to, really stay very balanced and neutral about these sorts of things. But the one challenge that keeps coming up when I talk about regulating this kind of online speech, right, is the analogy to things like mailers. And I think, agenda item 3 today with our oral argument gave us a really clear example of how, the code and the regulations approach speech that is from a falsified place, right? So these mailers were, they had, fake names and fake addresses, or one of them had a mail center that didn't actually have the sender's account there. So, we do regulate this kind of falsity in other places. We don't regulate it as falsity, we regulate it as a botch disclosure, right? And so here, I think, the most aggressive stance we could take, which is what we're not doing, would be to treat Twitter like the microblogging site that it is. And for anybody who's retweeting, consider that a microblog. And so then we've exchanged money to get this up there. And so then you would need a name and an address and a zip code and a city, right, of the person doing that speech. But of course, that's impossible because in many instances, they're not real people, right? And so I think that's the closest analogy I can come from. I can come to how we would regulate this without asking for the number, because I know that that's where the conversation is going to go, is right, the number. So I think that asking for the number of retweets or followers purchased is actually a much more moderate take on this, because if we were to try to get names and addresses and cities, then what we would be doing is regulating that kind of speech. I mean, it's just amplification. It's not really speech. There's not often a person behind it, right? We'd be regulating it into, oblivion. And so we're not taking that approach. We're doing something much more moderate, which I appreciate the CPAA for writing to us. I definitely disagree with the first point, which was kind of trying to say, well, you didn't want to use boosting broadly, and so you've narrowed the regulation, but now we're also going to say that's boosting. I don't really go along with that. But this second piece about compliance, I'm also not as persuaded by, because, like I said, the appropriate analogy, I think, would be a much harder compliance problem, almost an impossible one. And so I think we've struck a nice middle ground here. I also really appreciate the work of Mr. Lewis, and I appreciate the conversations that we've had as a commission about this, and I'm sure we're about to have another great one. So I'm grateful for that in advance.
Thank you, Commissioner Wood. Other commissioners have comments, questions for Mr. Bainbridge? Speaker?
Thank you. I want to echo my gratitude to our colleague, Commissioner Wood, for raising this and bringing her background to it. It's been very helpful as the many discussions we've had. My questions for Mr. Bainbridge is, I have, I think, two that are just understanding the language. So if we look at the regulation language, in the phrase that's right before the yellow highlighted language, including the type purchased, this has not jumped out at me before, but if we were to not have the yellow there, and we just had including the type purchase, what does that mean? Does that mean, the example you gave, you said Twitter followers. If someone is trying to comply with this, what more would they need to know that means?
I think that means follows, reposts, comments, however you would describe what it is that you've purchased. Because I think we want more than just to label it amplification. I think we want some description of what the product was that was purchased.
And I would agree there. I fall in the belief that the yellow is something I would like to see us not adopt, but having the information that you gave in the second example, and I think that's what you're trying to capture with including the type purchased. I wonder if are we being specific enough that that's clear? I wouldn't want, or maybe that's something we detail out on a fact sheet, as we've talked about in other times. I would just want to make sure, especially because terminology and technology changes, so that we are sure to cover what we intend to cover and not. Otherwise, if I were just to read that, it might be a little bit vague to me what that means without some more elucidation. We get a lot of advice letters, perhaps. I'm not sure. The second one is on page 4 of the memo. There's a mention of Gould School of Law professor Aaron Miller, and it mentioned similar feedback. I just wanted to know a little bit about what that was. I mean, it's a pretty fine point that I'm asking. It looks like it's perhaps in the First Amendment space. I requested, and it sounded like it was an informal conversation. Are you, is anyone on the team able to sort of elucidate on that one? Just a little bit. I know it's a pretty specific ask, so it's okay if it's not your fingertips.
No, I'm smiling because the person who could elucidate on it is in Europe right now, so we won't be hearing from him.
No problem.
My understanding is Commissioner Wood connected Torin with Professor Miller because she knew she was an expert, especially in First Amendment rights and as it relates to the internet. And so Torin and then the professor had a few conversations. He asked her to look at this and give her input, and I don't know if it was over email or a phone conversation, but it was an informal discussion where he was essentially picking her brain.
Okay, so there wasn't a letter somewhere that we were all getting. Okay.
Right.
And my only other one is in the CPA letter. One of the points that they raised, and just by way of background, I agree with Commissioner Wood on their first point about boosting being the same thing as what we're asking. I feel there is a distinction. So I certainly agree there. But one of the points they raise is that this should go on a Form 460 semi-annual report instead of, for example, on a 24-hour report. So I wanted a little reminder as I analyzed that question myself. If the 24-hour report, is that just when you receive $1,000 or more? It's not for when you all, I should know this, when you spend $1,000 or more. Can you remind us what 24-hour report is that's different? 460.
Sure. The main difference with it is the timing. So the major purpose that they serve is between the time that the second pre-election statement period ends and the election. This is the only disclosure that goes on of campaign expenditures and contributions. So that's their main purpose, is to capture that 16-day period. They now extend out 90 days before the election if the expenditure reaches the $1,000 threshold that you mentioned. But I think relevant to this discussion, really the focus is on that 16-day period from when the pre-election period ends to the election.
So a 24-hour report includes both expenditure and contributions over $1,000. Got it.
Independent expenditures and contributions.
Got it. And so I'm sorry, because when I went back to look at the regulation, I felt that I couldn't quite find where, and it could be that I'm missing a page, where we're saying that we're going to do it in the 16-day period or the 90-day period, or that it's going to be in the 24-hour report. Can you point me to where that is?
Sure. It generally applies to when you're reporting these. So regardless of what report it's on, it's how you describe this specific type of expenditure. And then you'll see in 18421.10A, there's cross-references to different sections.
Okay.
And those are the different sections that require a reporting. And so this is essentially defining what is required to be reported if it's pursuant to any of those sections.
Understood. The questions that I'd like your thoughts on the concern that the CPA raised on this issue of 24-hour report versus 460. I tend to be of the view that the less you make little exceptions about one thing or the other for this form or that, and you just try to be consistent, hopefully you are making it easier to comply. 24-hour reports, as we sometimes see, are sometimes a landmine. people accidentally miss it by a day, or they should know about it, but they don't, and it makes work for us, makes work for other people. So I'm always a little hesitant to have one more thing that has to go in a 24-hour report. But would we also be making, if we did what the CPA asked, would we be making some special exception that could also be a landmine? Or just in general, your thoughts about their point on 24-hour report rule versus 460?
Yeah, I think in terms of confusion, it could be potentially confusing because you would be saying, on these reports, you describe this expenditure one way, but if it's a different type of report, you describe it a different way. And then there's also the fact that you're saying this disclosure is important enough that we should have the full picture, but then you'd be saying, if we're not going to have it on 24-hour reports, well, it's not important enough that we need it in the last 16 days before the election. So I think it would be rather inconsistent to not apply it to 24-hour reports. I understand that they have to turn those around very quickly, and that would be more convenient to them, but I think it would be inconsistent.
That was, originally when I read it, I thought, gee, that's a great point. And then I just thought about this, you may be setting up a whole nother landmine inconsistently. So thank you. Where I am supportive, and I think I've mentioned, of the position of excluding the language in yellow and making it clear to those and transparent that this is instead an expenditure that was used to buy followers, providing additional information as to how many likes and whether it's likes versus comments or otherwise, to me does disclose what I would consider proprietary and almost campaign skill and strategy information that we don't have a corollary for, like we don't, as the CPA letter mentioned, how many mailers you do, how many of this or that you buy. They pointed out a couple examples. That's where I land on this one. Thanks to the good work that our team has done and Commissioner Wood's persuasiveness, I think addressing amplification is something I really like to see us do. That's where I fall on it, and that's what I would be supportive of here. Open to colleagues as well.
Thank you. Do other commissioners have questions, comments for Mr. Bainbridge? Well, seeing no other comments, I mean, the one, for my piece, I think it's incredibly important that we adopt the regulation with the yellow language included, which specifies the number of shares, likes, et cetera. I think that's critical to understanding the degree to which this activity, which again is pure misinformation. I mean, these are fake. These aren't real people. This is fake information, for lack of any other possible term, that's being put out there by a campaign. And I think it's absolutely fair. I mean, we are not prohibiting it. We don't have the authority to do that, but we do have the authority to require folks to be transparent with efforts. With respect to the concern about giving away a campaign strategy, I tend to think the number of likes, number of shares is a relatively small aspect of overall campaign strategy. And certainly wouldn't be any greater reveal, if you will, than the existing rules that require people to disclose when and what stations they run a television ad on, or where they run a radio spot and what times of day. You could back into their strategy by knowing just that information. And I think that's actually a lot more of a peek into their campaign strategy than simply the number of likes or other things that they've purchased. So I'm not quite as concerned about that piece of it. So for my part, I would recommend that we adopt the regulation as presented with the yellow language. And let me just turn that into a motion. I will move that we adopt the regulation, including the yellow language as presented by staff. So do I have a second?
I'll second.
Thank you. And so,
can I make it?
All right, Mr. Bainbridge, parliamentary question.
Well, you could propose an amendment to the current motion, and then you could vote on the proposal for an amendment.
I'd like to do that. The regulations.
I'm sorry, we can't hear
I am
what's
not
going on.
on. There we go. That's why, because I forgot to push the button. I apologize. I was just going to adopt move to adopt an amendment to the motion to adopt the regulations without the yellow language. I don't know if I'll get a second for it, but I'm going to move for it. Thank you.
Thank you.
I'll just do the courtesy of the
Commissioner Wilson, it's up to you. I was getting ready to call for public comment on the original motion, but it's up to you.
motion to amend it.
If it gets a second.
We couldn't hear Commissioner Wilson either. I'm sorry.
Sorry. I'm sorry, I apologize. I didn't have my microphone on. Out of courtesy, I will second Commissioner Baker's motion to amend.
Let's call for public comment now on the motion and would result in adoption without the yellow language. All right, public comment. Hearing and seeing no public comment on item 11, Ms. Linker, would you please call the roll? And this is the motion to adopt without yellow language.
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
No.
Commissioner Wood?
No.
Chair Matich?
No.
The motion fails.
We now have the original motion pending. That motion is to adopt the regulation as presented by staff, including the yellow language. Moved and seconded. Please call the roll on that motion. Well, we'll call for public comment again on item 11 now that we are returning to the original motion. Hearing and seeing none. Ms. Lincoln.
Commissioner Baker?
No.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Am I allowed to modify my vote?
Mr. Bainbridge, parliamentary question. May Commissioner Baker amend her vote.
I assume we could reconsider the vote and take another vote. Would that be your understanding, Commissioner Wilson? Okay, I didn't know if you had an opinion.
We'll do it.
We could have a motion to withdraw the prior vote and then have another motion to vote again.
I will move to reconsider. I have a second.
Second.
Second. Second.
Commissioner Baker?
Aye.
Commissioner Cardenas?
What are we voting on again?
Commissioner Cardenas, we are voting, Commissioner Baker has indicated a desire to potentially change her prior vote, and she has asked that we reconsider the vote that we just took, which would result in adoption of the regulation with the yellow language included, to allow us to recast the vote on the original motion.
Right. Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Now, make a motion again to adopt the regulation as presented by staff, including the yellow language.
And I'll second.
We'll call the roll.
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you, everyone. Thank you to the commission and to the staff that worked very hard on this. Appreciate your efforts.
Thank you.
All right, moving right along, on to item 12. Is adoption of amendments to the record-keeping requirements for lobbyists, lobbying firms, and lobbyist employers. This is our senior commission counsel, Zachary Norton. Mr. Norton.
Just 1 second. I'm connecting to through Zoom.
Take your time. Yeah.
Good afternoon, Chair Matich and Commissioners. I'm Zachary Norton, Senior Counsel with the Legal Division, presenting for adoption today amendments to Regulations 18610, 18612, and 18615, the record-keeping regulations for lobbyists, lobbying firms, and lobbyist employers. So one of the primary purposes of the Act is to ensure that activities of lobbyists are regulated and that their finances disclosed in order that improper influences will not be directed at public officials. In furtherance of this purpose, the Act requires lobbyists, lobbying firms, lobbyist employers, and persons who spend $5,000 or more in a calendar quarter to influence legislative or administrative action to file quarterly reports of their lobbying expenditures with the Secretary of State. The Act imposes specific reporting and accounting requirements, including requirements to maintain records for all receipts and payments for lobbying activity. The disclosure of activity expenses is important in tracking the attempt to influence legislative or administrative action. The Act requires that the Franchise Tax Board, or FTB, conduct mandatory audits of lobbying firms and lobbyist employers. A special unit of the FTB is tasked with conducting these mandatory audits, and the findings, known as audit reports, are to be sent to the FPPC. Both the FTB and the FPPC may also conduct discretionary audits. An effective audit requires that detailed records be made available to auditors so that all reported receipts and expenditures may be verified, and that any activity which was not properly reported may be identified by the review of records provided. And we envision these changes as the first step in facilitating additional lobbying audits. This agenda item involves amendments to lobbying record-keeping requirements. The proposed amendments include the addition of specific records that lobbyists, lobbying firms, and lobbyist employers must maintain, as well as other amendments clarifying the application of existing subdivisions. These amendments are being proposed to facilitate the conduct of more accurate and effective audits. Greater specificity as to the records required will make the audit process more efficient for both the auditors and the subject of the audits. Our goal has been to make specific the types of records that auditors will need to reconcile reported receipts and expenditures with supporting documentation. To that end, staff has worked with Luz Benetti, our lead auditor, and consulted with FTB on identifying the additional types of required records included in these amendments. So both Luz and Bob Perna, one of our other auditors, performed lobbyist audits to get a sense of the regulatory changes that would be needed to facilitate more meaningful audits. They conducted discretionary audits of 3 lobbying firms and 3 lobbyist employers. Bearing in mind what is required to be disclosed, the auditors sought to establish what records are needed to substantiate this disclosure during the course of these audits. Their findings have guided the drafting of these amendments that are before you today. And auditors have stressed the need for both internally and externally generated records, not just records generated by the subject of the audits. And this proposal includes requirements for more original source documentation, which allows for independent verification of the information disclosed on audit lobbying reports. But to this end, we're also narrowing the scope of the permissible use of internally generated vouchers to prevent the potential abuse of this process. In short, the more independent verification we have, the more effective the audit. Current regulations. And these regulations concern the record-keeping requirements for lobbyists, lobbying firms, and lobbyist employers. The regulations all contain relatively similar provisions, but all lack specificity as to the types of records that must be maintained. Proposed amendments. The current requirement to maintain a journal or other record is described differently in each of these 3 regulations. Staff proposes using the term journal, ledger, or other record in all 3 regulations to make this requirement consistent. With the widespread use of accounting software, the term journal may be outdated or too restrictive depending on the form of accounting employed by the entity. The proposed changes allow for greater flexibility in record keeping to track receipts and/or payments. Proposed amendments to all 3 regulations identify categories of source documents that must be maintained to substantiate information in the journal, ledger, or other record. They also provide some specific examples of records to be maintained, as well as add a requirement that legible images of canceled checks be maintained in place of the canceled checks themselves. While the existing regulation includes some records that must be maintained, these additional records are necessary for a thorough and effective audit and verification of accurate reporting. These records are necessary to corroborate the information contained in the journal, ledger, or other record. And under current banking practices, canceled checks are no longer provided to account holders, while the scanned images of these checks are available through online banking. This proposal also replaces the broad standard existing in all 3 regulations, which allows for a written voucher to be prepared when it is impractical to obtain a receipt or invoice, with a much narrower exception where the voucher will only be allowed in place of a receipt or invoice in the event that the source document cannot be obtained. The existing state regulation states that a written voucher may be prepared in the event that it is impractical to obtain a receipt or invoice. Current technology easily allows for vendors to print receipts or invoices, even for transactions that have occurred long in the past. And such documents are routinely obtained in enforcement cases where the documentation is otherwise not available. So this exception is really only necessary in circumstances where this documentation just cannot be obtained. With that, I will address public comment. So we did receive public comment from the Institute of Governmental Advocates, and we have addressed most of their concerns in the regulations that are before you now, those being the concerns that were expressed in the letters that were attached. And I did have one remaining conversation, and the remaining concern involved the use of the term including when providing specific examples of records for the categories of source documents that must be maintained. In order to address this concern, we are proposing making the following changes, which would replace the term including with such as. So for regulation 18610, C1 and 2, and that is that's page 3, lines 3 and 6, We would change including to such as.
Sorry, which page and line again?
Page 3, and that's lines 3 and 6.
8610, that's the regulation you're referring to?
Yes.
My exhibit, there's page 3, only has 4 lines.
Could it be page 2, line 2?
Page.
I think you may be right, but let's tell us.
Sorry. I'm sorry, yes. It should be page 2. I'm sorry.
Okay, so I just want to make sure we're absolutely
Yes,
clear. Talking about 18610, lobbying and accounting.
Yes,
And that's page 2, go take it.
yes. And then it'd be line 3, and then line 6. Yes, that is correct. The other change is 18612. It's also changing subsections C1 and C2. So that should be page 3, line 3 and 6. And then for 18615, that is subdivision D1 and 2, and that would be page 6, lines 5 and 8.
Mr. Norton?
No, and I'll just stress that, you know, we agree that these changes are warranted because we're just making clear that these are categories of records and that these are actually examples of records, so that to the extent a particular record may not exist because it may not be pertinent, that such as is probably a better term to clarify. And Institute of Governmental Advocates is otherwise happy with the current version. We have been in contact with them, and they are supportive of what we're doing. So.
Well, they can ask just a follow-up to that. I mean, I appreciate that IGA is pleased with the draft.
Yes.
Doesn't oppose it. My question, though, is from staff standpoint, and you had mentioned staff had conducted some discretionary audits to try and tighten up our regulations and the best way of improving transparency.
Yes.
Are we satisfied that all of these changes accomplish that goal?
Yes, yes. I can say that we are satisfied. And I think it was our concern, you know, when I was working on this, first and foremost, I wanted to hear back from our staff as a result of the 6 different audits they have worked on. What is it that we really need to make sure that they're effective? And go with that in mind, then looking at public comment, just to make sure that what we're requesting is not going to be burdensome or confusing. And I think that's part of the goal in these changes, is that it gives staff regulations that they can point to when the audits are being conducted. So, okay, here's everything that you need to maintain, but also to make sure that this notice, I think, will also be helpful to the regulated entities, as it provides plenty of notice to them. If you are selected for audit, these are the documents that we will expect you to produce. Now that when they are selected for audit, they are notified. They send out a notice that says, now that you're going to be audited, here are the types of records that we'll be looking for. But I think having it in a regulation makes it clear up front. I think that will facilitate more streamlined audits. It won't be a surprise to anyone that if you are selected for audit, someone will be contacting you and will be looking for these particular sets of records.
Thank you. I appreciate that. All right, Commissioner Wilson?
Just a couple technical questions. Thank you, Mr. Norton, for all your hard work on this. This is kind of just a general question. As it relates to the journal that lobbyists either maintain or will be maintaining, is there any specific format that we're recommending be followed, or is it kind of general in terms of, you know, what kind of journal a lobbyist would keep?
We are not recommending a specific format, and I think that was part of our motivation in moving from journal, ledger, or other record. I think ledger, it does sound like kind of an old-fashioned term where it's pen and paper and using a book. But apparently there's various accounting software programs that I believe many of them are using. So with that being said, it's kind of the idea that if they have software, they can provide us the printout spreadsheet. And that was something in talking to Bob and Luz too, that we don't want them to feel like, well, we're not, if you're being audited, we're not asking you to go create separate records. We just want to look at the records that you have maintained in the course of your normal operations, be that some sort of QuickBooks accounting software or a ledger or whatever it is that you have.
And then my other question is, thank you, as it relates to the, the discussion I think issue was raised by IGA, a lobbyist employer versus lobbyist sponsored event. That was clarified to your satisfaction as well?
Oh, yes, it was. Yes.
Okay. All right. Thank you.
Any other commissioner questions, comments for Mr. Norton? Hearing and seeing none. Mr. Norton, let's go ahead and call for public comment on this item. This is item 12, lobbying firm and lobbyist employer record keeping proposed amended regulations. Any public comments? Hearing and seeing none, I'd make a motion to approve the proposed regulations in item 12 with the additions that Mr. Norton described to us today, striking the word in various places, including and substituting such. I have a second.
There's the late public comment, which seems to be positive, but I second that.
Yes. Thank you, Mr. Hilltag, for organization support. We have a second. Ms. Lenker.
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Excellent. Thank you, Mr. Norton, and thank you to the staff, Ms. Benetti and Mr. Parna, who also worked on these regulations.
Yes, it's.
I can add to that, just what a great process to do a test run and made it very, very concrete and real. And gives a great deal of confidence in these regulations. So thank you for that process.
All right, moving right along, we will move to item 13. This is our legislative development. We will welcome to the table our Ledge Council. By the way, I misspoke. It's not Ledge Council, Ms. Nakano, it's Senior Legislative Council. Apologies. And while you're getting set up, so one of the things that Ms. Nakano is going to be presenting today is our slate of legislative concepts for the next legislative cycle. And she has a number of items that we talked about last month. And the way I would like to treat those for purposes of the commission's vote is to present them as a single package of ideas, but provide commissioners with the opportunity to pull an item from that list if you want to talk about it separately. Otherwise, we would treat it like the consent calendar and approve the entire slate of legislative ideas in one vote. So that's the plan going forward. So I'll turn it over to Ms. Nakano. Good afternoon.
Good afternoon, Chair Matich and Commissioners. So as the Chair mentioned, I will be presenting the legislation ideas for next year, and we'll ask for a vote at the end. After the Commission votes today, I'll continue to reach out to potential authors and interested parties on these proposals or those that are approved by the Commission, and that will be a bipartisan effort working with both sides of the aisle. Before I move on to the legislative proposals, I wanted to quickly mention that the legislative calendar has been released for next year. It's attached to the agenda for your reference. I'll move on to the proposals for 2022. I have a PowerPoint to share.
Okay, first up is the Digital Campaign Ad Archive proposal, which of course came from the recommendations of the Digital Transparency Task Force. I think the Commission by now is pretty familiar with the background of this idea, but I wanted to stress that the driving force behind this one is really the fact that the existing tools available to review digital campaign ads fall short, which is to say that it can be sometimes nearly impossible to get information on what campaign ads have actually been released to the public in the digital world. So this proposal would require a committee that pays for a digital campaign ad to submit a copy of the ad and other specified information to the FPPC or another designated state agency pursuant to a specified deadline. It would also require the FPPC or another agency to make that information available in a publicly accessible online archive, and would require that archive to include user-friendly functions such as expanded search capabilities and the ability to download raw data. And the major benefits, of course, are to create access to these ads for voters, the media, researchers, the FPPC, and other committees and candidates. And that increased access means greater transparency on the messaging issued by committees and the interests funding campaigns. We're phrasing this currently to refer to the FPPC or another state designated state agency, but any legislation would ultimately specify precisely which agency would be responsible for the archive. This next proposal also came from the task force and asks the question, can we make disclaimers on digital ads more effective? Disclaimers exist to give the public valuable information about who is paying for an ad, which then gives information about who is supporting or opposing the subject of the ad. Current disclaimers were modeled after those on TV and print media, and this proposal asks for a fresh and data-driven look at whether different kinds of disclosures would be more effective in these newer digital media formats. Specifically, this proposal would require the FPPC or another designated state agency to contract with a qualified third party to conduct a study on the effectiveness of disclosures on digital campaign advertisements and to make recommendations about what kinds of advertisements would be most effective. The study would be required to include public engagement and consider at a minimum the form, content, placement, and wording requirements of the disclosure. The bill would also provide guidelines for the research process. And the major benefit here is that the results of the study would provide research-based recommendations for amending the disclosure laws in ways that boost transparency for the public about the money behind campaign ads, digital campaign ads specifically. This next proposal is currently an AB 775, which will be taken up as a 2-year bill early next year. This proposal came from reports that some campaigns were turning one-time contributions into recurring contributions without necessarily obtaining the donor's affirmative consent and sometimes without the donor's actual knowledge. The proposal requires a candidate or committee to obtain affirmative consent from a contributor in order to sign them up for recurring campaign contributions. It also requires a candidate or committee that accepts a recurring contribution to provide a receipt for each contribution, provide information necessary to cancel the recurring contribution, and to immediately cancel the recurring contribution upon request. The benefits here are increasing transparency surrounding the campaign transactions of committees and boosting transparency to contributors by ensuring that they are actually and effectively informed about the nature of their contribution. And I'll also note that conversations with staff on the bill about potential amendments are occurring and are ongoing. This next proposal is also all about transparency, but this time in the realm of lobbying. So lobbyists, lobbying firms, and lobbyist employers are required to submit quarterly reports. These reports provide general information about lobbying activity and payments, but provide only minimal information about the more detailed subject and substance of the lobbying activity. Currently, lobbying reports are required to be audited by the Franchise Tax Board, but unfortunately, no audits of lobbying reports were completed for the 2017-2018 reporting period, and none are expected to be completed for the 2019-2020 reporting period, which has resulted in several hundred lobbying firms and lobbyist employers not being audited as required by the Act.
The FPPC currently has authority to conduct discretionary audits of lobbying reports, which was just mentioned in the last presentation, but does not currently have funding to complete a significant number of these audits. So this proposal addresses these issues first by adding to the information reported by lobbying firms, lobbyist employers, and lobbyists. Staff is proposing 3 different changes. First, requiring a lobbyist to report the name of each member or officer who the lobbyist communicated with for the purpose of influencing legislative or administrative action, and a description of the specific lobbying interest lobbied, which in the legislation context would include information like the relevant bill number. Second, the proposal would also include requiring faster client registration by requiring a lobbying firm to amend its registration no later than 48 hours from a change to its clients. Currently, these amendments are required to be filed prior to the lobbying firms attempting to influence any legislative or administrative action on behalf of that person. So this is already a requirement. It would just be sped up a little bit and require a shorter turnaround. And last on reporting, the proposal would include a new 24-hour report for lobbying firms when they start lobbying on a legislative or administrative action. This report would be submitted directly to the FPPC. Onto the audit side, the proposal would transfer the duty to conduct mandatory audits of lobbying entities from the FTB to the FPPC's audit division, and would exempt from mandatory audits, excuse me, placement agents and lobbyist employers and lobbying firms that make or receive less than $25,000 for lobbying services during the 2-year audit period. This would allow, excuse me, losing my voice. This would allow the auditors to focus resources on traditional lobbying entities engaged in more significant lobbying activity. On the reporting piece, this proposal would provide the public, legislators, the FPPC, and others with more substantive information about the interests influencing legislative and administrative actions. On the audit piece, audits are a crucial tool for discovering violations of the Act. Additionally, the real possibility of being audited may result in better self-regulation by those required to report. By transferring the lobbying report audit duty, the FPPC can ensure that these audits are prioritized and completed, which would result in increased transparency and better enforcement of the Act. This next proposal addresses the use of public funds for campaign communications. Current state law generally prohibits public officials from using public resources for campaign activity. The PRA currently requires reporting for payments by state and local government agencies for public communications that clearly identify a candidate or ballot measure. This proposal would codify and clarify the rules relating to payments by state or local agencies for campaign-related communications, and would provide that under the Act, communications that clearly identify a candidate or ballot measure sent by a state or local government agency at the public expense are prohibited, unless the communication fits into a specified exception. The proposal would also provide examples of prohibited communications, including but not limited to prohibited mass mailings, bumper stickers, billboards, print media, and mass media communications. By clarifying the rules, this proposal would create greater certainty for the regulated community and would aid in compliance with the Act. And by prohibiting these communications under the Act, the proposal would provide greater protection for the public from government agencies and officials impermissibly spending public funds to influence elections. So for background on this next proposal, the Commission has a successful electronic filing system for statements of economic interests, but the use of the system is voluntary and some filers are not taking advantage of the e-filing system. This proposal would require public officials for whom the Commission is the filing officer to file using the electronic filing system that the Commission's electronic filing system. This proposal would further the general modernization efforts of the Commission, reduce staff time spent on processing, reduce facility and storage costs over time, and increase transparency by ensuring that all of these SEIs are available in a searchable format. Additionally, the e-filing system provides a faster and easier filing experience for the filer by pre-filling in many fields in the form after the filer submits their initial SEI. This next proposal addresses how we might be able to increase access to out-of-state parties and committee bank records during the course of FPPC investigations and audits. FPPC investigators and auditors often experience delays in and roadblocks to obtaining records during the course of an investigation or audit. Delays can occur when committees' bank accounts are not clearly identified, when individuals with access to records are unavailable or unresponsive, and when records or parties are located out of state. So staff came up with a number of options to help address these issues, which include creating a long-arm statute to give the FPPC jurisdiction over non-resident parties subject to the Act, and to subpoena out-of-state records connected to an investigation or audit. This would save significant time and resources in reaching out-of-state parties and obtaining out-of-state records associated with parties under investigation or audit. Another idea is to require better designation of committee bank accounts, such as through bank account naming requirements or disclosing bank account numbers in committee filings. And this would be done in such a way that private and sensitive information like bank account numbers would be available only to the FPPC and would be redacted on any public copies. This better designation and identification of committee bank accounts would allow investigators and auditors to more efficiently track campaign transactions. And the last idea is to require at least two people, likely the treasurer and the candidate or assistant treasurer, to be authorized signers for committee bank accounts. This allows there to be an alternate who can directly access bank records if the treasurer is unavailable or unresponsive. When the authorized signer is unreachable, complete records are difficult to obtain and delays to the auditing and investigation process can occur. FPPC auditors have noted that even if a candidate wants to directly access their own committee bank records, they're unable to do so if they are not authorized signers. This next proposal would grant FPPC special investigators authority to access what is referred to as state summary criminal history information when needed in the course of an investigation. Several other state agencies with investigation and enforcement units have access to this information, which must be requested from the AG's office. Having access to this information would aid investigators in more effectively and efficiently researching individuals under investigation, contacting witnesses and respondents, and protecting investigator safety in cases where the investigator may be meeting with a person meeting with an individual in person. This next proposal addresses a problem that arose at the beginning of 2021 when the gift limit was raised to an amount that, for the first time, exceeded the income threshold for conflicts of interest. Because of this change, there can now be situations where a gift would not create a conflict of interest, but earned income in the same amount would create a conflict of interest. This creates an uneven, illogical, and arguably unfair result. By capping the gift limit at $500, which is the same as the income threshold for conflicts of interest, this proposal would reconcile that discrepancy. This last proposal avoids penalties for over-disclosure on certain digital ads by allowing committees to include the full disclaimer directly on the digital ad itself, instead of just the who funded this ad hyperlink, which is the current requirement. Eliminating penalties for over-disclosure on these ads would free up Enforcement Division resources spent investigating complaints for this over-disclosure, and would allow committees to avoid technical violations where there is no harm. So that concludes the presentation of the proposals, and I'd be happy to take any questions or facilitate any discussion.
Thank you, Ms. Nakano. Any questions for Commissioner Baker?
Thank you. Thanks for a great update. One question is not about the list, and I probably should have asked this beforehand, but sometimes this time of year, the committee chairs change. I saw news that the chair of the Elections Committee has been appointed, and the Assembly has been appointed to another committee. Do we know if we have a different, has a new committee roster come out yet that you're aware of? Are there new people out over there in the building on these committees?
I don't have that information now, but I can provide that after this meeting.
Thank you. I didn't know if that shuffle had gone around. My questions are limited to the first item, and it's just to, understand. I know we've had some conversations about parts of this recommendation, and I'm certainly comfortable with heading over to the legislature and finding out what they're willing to take up and potentially pass. But under sub B, just to be specific, it mentions this proposal would require the committee to submit a copy of the ad and other specified information. Are we being specific in what we are bringing forward to the legislature as a proposal at this point? And is it what we've talked about before, which is targeting information? Is that what other specified information is here? Or are we open-ended in this description to legislators as we approach them?
I think the initial starting point will be the recommendations of the Digital Transparency Task Force. So that will be where I'm coming in as a starting point, since the Commission has approved that report and those recommendations. As it evolves, or if the legislature has other ideas, or if the author has other ideas, then that would be something I'd come back to the Commission with, if there are any changes or other thoughts on that.
And I've already weighed in on my thoughts on that part, as well as the broader adoption of the report. And the second one is little 3I B on the top of the next page, and that is the ability to download raw data. Can you just remind me what the raw, I forget what the raw data was from when we talked about the task force, but what is that?
From my recollection, this might be something like an Excel document where all of the data will be in columns and rows, and they can download that into Excel and then manipulate it, sort it however they'd like to find trends, make charts, that kind of thing.
Okay, and the data that goes inside that Excel is the targeting information, or is it like who the candidate is, or where, or?
Presumably, I'm not sure exactly how this would work, but it could work such that the columns show what was input into the digital archive, and then the responses for each of those. So it would presumably include everything that they included in their report that's available on the archive.
Thank you. I do have a favoritism against the targeting information, as we've talked about before, so I won't belabor that, but I look forward to seeing what kind of reception we get for overall transparency with these ads, and certainly the study on what's going to be the most meaningful disclosure. So thank you for that.
Commissioner Wilson?
Thank you, Chair Matich. Senior Legislative Counsel Nakano, thank you for your presentation. My questions relate more to comments relate more to page 7 and page 9 in terms of the automatic recurring contributions. I think we'd be remiss not to recognize the input that the chair and vice chair have had on this process. I think it was back in August. They submitted an opinion piece to the Sacramento Bee and I think some other additional media outlets. And I think that really highlighted the impact that this legislation could have on the whole issue of recurring payments. And then my second comment or question relates more to, it's on page 9 regarding lobbying, reporting, and audit reform bill. Could you explain, and maybe it's in general terms, how this 24-hour report for lobbying firms would actually work, and would it be throughout the legislative year or just during certain periods of the legislative calendar?
I don't think we've narrowed down exactly what we'd want this to cover. It would make sense for it to be only during the legislative year, or at least only during certain months, potentially. We haven't narrowed that down yet. What I envision this to be is sort of a notification to the Commission that would be made public when a lobbying firm starts reporting or starts lobbying on a legislative or administrative action. So it would be, I imagine, a short form. They're just saying, we started lobbying on A, B, whatever, and...
You know, I mean, because I mean, correct me if I'm wrong here, but that could be hundreds, if not thousands, of interaction that can occur. And because at the state level, at least in the legislature, there aren't the same prohibitions that exist at the local level in terms of, communications between elected officials, so-called serial communications. It seems to me that the 24-hour reporting requirement, unless it's more closely amended, I think that could be problematic. But that's just my initial observation. That was the last of my questions.
Any other commissioners have questions or comments for Ms. Nakano? I have a question about the gift limit. Actually, it just occurred to me. Historically, the gift limit was lower than the limit. Right? So I guess my question is, do we know or have we looked into why that limit? Because now we're proposing that they be set at the same amount. So my question is, have we looked back to try and understand what the intent was in having the gift limit be lower than the conflict? So I'm putting you on the spot. I mean,
Yeah, I would speculate that a long time ago, maybe we didn't realize that we would eventually get to $500 or more for a gift limit way back when they put these in place. And I think and it's tough with the act to say what the original intent was because there's not much legislative history on it. My guess would be they wanted a set amount that stayed the same for purposes of conflicts. That was easy to remember, and it makes a little less sense to tie that, I think, to inflation, whereas maybe gifts and contributions, it makes a little more sense to tie that to inflation. So my guess would be it was a long time ago, and they didn't foresee getting all the way up to $520 for gifts. Or maybe they thought by then people will have changed what the other limits are. But that's just me guessing.
All right. Well, I appreciate that. And I think our proposal to align them makes sense for all the reasons that Ms. Nakano expressed to us. I do think, and I would offer this recommendation, you may want to try and solicit some feedback from Ms. Byrne, who I know testified before our commission a while ago. He was one of the authors of the act, and just see if he did or if the authors did have a particular intent in mind, just to make sure we're not inadvertently doing something that would be contrary to what they originally.
I'll defer to the other commissioners if they want to comment, but I have a related question regarding the gift limit.
Yeah, go for it.
Okay. It's my understanding, Mr. Bainbridge, and you might be able to shed some light on this, or Ms. Nakano, as it relates to the gift limit, it's subject to cost of living adjustments, right, over time. What is the process, if any, to increase the $500 income threshold?
That number is not tied to a COLA adjustment, so you would have to make a statutory change.
Yeah. So it's like the lunch, when they set the limit for lunch or dining, when the act was first proposed, there's no cost of living adjustment for that particular aspect of the act. So I guess my question is, would it be possible to perhaps look at a legislative solution where you could the $500 income threshold could be adjusted either by the commission or tied to some kind of cost of living adjustment so that you could potentially avoid this problem? More of a rhetorical question. I'm not looking for an answer as much as to say that if you could adjust the income threshold, which doesn't mean the same in 2021 as it meant in 1974, then you could perhaps avoid this, this particular problem, because 20 years from now, will a $500 gift limit make sense? Or $520 gift limit, whatever it actually is set at.
Yeah, it's certainly possible. It's all set by statute, so you can change the statute.
Commissioner Wood?
Yeah, I just want to second what Commissioner Wilson was just saying. You know, we see sometimes in the court cases on these things where contribution limits aren't inflation adjusted at certain states, that the court, if they're going to strike it down, will mention that fact, you know? And so it seems like just like a worthwhile thing to go ahead and try to tie it to cost of living, inflation, however we want to index it. But I just wanted to support what Commissioner Wilson was saying.
Any other questions or comments for Ms. Nakano on the legislative slate that we have? All right, is there any public comment on item 13? Hearing and seeing none, then I would move approval of the slate of legislative concepts that Ms. Nakano has presented.
I can second.
I have a question.
Okay,
Is,
Commissioner
and I don't want to slow down the process, but is there any possibility of, you said we could have a separate vote if we didn't want to have a particular item on the consent calendar?
If a commissioner would like to pull an item, then now would be a time.
Yeah, I mean, it's really tied to the 24-hour reporting provision, but I think the lobbying, reporting, and audit reform bill should be voted on separately, because I think there are some real issues with the 24-hour requirement, and I would appreciate a separate vote on that.
Okay. That one. Any other commissioners wish to pull an item for a separate vote from the slate?
Happy to pull the first item.
Okay.
Thank you.
So the remaining, the two items we've pulled from the legislative slate are items 1 and item. This time, I will move approval of the remaining slate of legislative. Is there a second?
Second.
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Now proceed to a separate vote on item 1, and I would move approval of item 1.
I'll second that.
No, we're going to vote on it separately.
Well, we're voting. I made a motion on item 1.
Right.
Right. And Commissioner Baker has asked.
And I don't know if this is in the form of amendment. It's just, I would appreciate that, I know, and as a collaborative member of this commission, I did vote for the task force. I think I've been pretty straightforward about the concerns that I've had about the targeting information and what would then become the downloadable information. And I think it is fair in working with the legislature, they're just aware that there was certainly unanimity with the task force. There have been some questions raised, at least by one member, about the amount of information that is disclosed. So I don't know if that needs to come in the form of a separate motion, but or if it's micromanaging our senior legislative counsel, which would not be my goal. I don't want to go over myself and sort of say, gee, this is my opinion on this separate point. So I'd rather do it as a commission, that as we're having conversations about this, that not only are we open to feedback on it, but they are understanding that that particular provision was a subject of debate within our commission. And I don't want to make it sloppy with the motion, so I'm open to your suggestions on how to handle that.
Well, I think what I'm hearing is your continued reservations about one aspect of the transparency task force report, and I think that concern has been part of the record at time we've talked about it, including today, and so I think your concern is in the record already. I'd like to make a particular, or do you want to vote against it? I think that's, at this point, I think we've...
Where we're at, got it.
Yeah.
Okay.
Yeah, I think the record's been pretty clear.
I appreciate that. I withdraw my motion, or attempt to make a second motion, so I appreciate that.
All right.
Thank you.
We have a motion on item 1. I thought I heard Commissioner Wood second that motion.
Yeah, I did.
All right. Ms. Wicker?
Commissioner Baker?
No.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Now we'll proceed to item number 4. I would move approval of item number 4 as presented by Ms. Nakano. Again, consistent with, I think, our prior comments that if there are concerns that are raised during the legislative process, those come back to the commission, so we have further opportunity to refine these. That understanding, I would move. I have a second.
Second.
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
No.
Commissioner Wood?
Yes.
Chair Matich?
Aye.
The motion passes.
All right, Ms. Nakano, thank you. My understanding is that between now and January, you will be taking these concepts and reaching out to folks to gauge their interest in authors for us. So we can expect a report back from you in January on your efforts?
Yep, I think that's a good timeline to go by. I'll have a lot to update by January, I'm sure.
Okay. Thank you very much, Ms. Nakano.
Thank you.
Mr. Chair, before we move on to the next item, I just want to remind you I've got about 10 or 12 more minutes before I need to hop off. So if I won't interrupt again, I'll just hop off, when it comes time for my next thing.
I appreciate that, Commissioner Wood. Well, Commissioner Wood, let me ask you this. We can skip to item 16 or to any of the other items if there's one item of particular interest to you at this time.
No, I think everything looks great. Thank you.
All right, thank you. We'll just.
Mr. Chair, with apologies, I will also need to take my leave in a few minutes.
Okay, thank you, Commissioner Cardenas.
Thank you. Apologies.
Item 14 is our fiscal year 2021-22 first quarter expenditure report. Chief of Administration Hahn. Good afternoon.
Good afternoon, Chairs and Commissioner. I'm here to provide an update on our fiscal for this current year. With the expenditure report, as you can see, that the expenditure have came in within line of the original projection from the beginning of the fiscal years. So we're looking good.
Any commissioners or comments for Ms. Hahn on her expenditure report?
One quick question. In terms of the audit responsibility shifting from the Franchise Tax Board to the FPPC, that'll be incorporated into our new budget.
Actually, there has not been any budget shift from that because the legislation has not been adopted or approved yet. So therefore, there would not be any additional.
So that'll be incorporated into any the legislative action. Okay.
Yes.
Just wanted to clarify.
Thank you.
Important point to clarify on that one. All right. Any other questions for Ms. Hahn on her report? And seeing none, thank you, Ms. Hahn. Ms. Hahn, any public comment on item 14 before we let you go? And seeing none, thank you, Ms. Hahn. All right, moving on to item 15. These are executive staff reports. And with us first, or the table, is Chief of Enforcement Brereton. Welcome back.
Now, thank you. The only thing I would like to point out is I added on page 5 under subdivision C the topics that we will be covering, the general topics that we'll be covering in December at our presentation. So we'll have an overview of enforcement and its processes, 2021 workload recap, a streamlined program update, a pre-election outreach program, and 2022 election year projections.
Thank you, Chief Brereton. Questions or comments for Chief Brereton on the Enforcement Division?
Thank you, and thank you for, outside of meetings, reaching out to myself and I know other commissioners to ask, are there any other topics? And I wanted to clarify the pre-election outreach program is that the, just to make sure, it may cover some of the topics I gave feedback on. What is that? What is that one?
So in general, the pre-election outreach program will talk about how we approach our pre-election efforts when we have, during an election year. Okay. Because we had a gubernatorial recall in 2021, we will also discuss how we approached pre-election for that, since it was unique. So it will be incorporated in the presentation.
So that, for example, is when complaints are filed close to an election, you'll be able to update us on what enforcement division's process and policies are for dealing with things like that.
That's correct.
Okay. Just looking for a translation. I want to make sure that was on the list. And I understand that the other topics, just for transparency with my colleagues, you know, I had requested that we also hear about when there are fines that other agencies and authorities use, how that may weigh into the enforcement process. That's come up in some of our conversations in the last year. There are also, when we're allowed, perhaps when we're looking at a stipulation, what the policies are for looking at outside information like news articles or what's in the public domain. I had put that in the request. Understanding what precedential value stipulations may have. It was an item of great discussion back in our September meeting, and just getting a better sense of how that's done. There were a couple other ones that I had just shared individually. I'm sharing now with my colleagues that I had made that request because this is the only public way in which we're all talking to one another. So you've got the heads up on that. It'll be great. It's my understanding you intend to include some of those points in your enforcement update, and I'll look forward to it. Really appreciate the hard work.
Thank you.
Any other comments or questions for Chief Brereton? Good. Fair enough. Thank you, Chief Brereton. Appreciate it.
Thank you.
All right, next up, Legal Division. Mr. Bainbridge.
Okay, just a few announcements in addition to what is already in the report. We have hired a new head of our education group. It's Chloe Hackert, who has been with the commission for some time. She's actually started here as an intern back in college. So she's been with enforcement for a number of years and now has taken on the task of heading up the education division, which has grown because we've had the diversion program, which we've just started to work on, and we've hired the manager for that program, which is Dominika Wojcinska. Also comes from enforcement. Sorry, Angela, for rating your staff. But I think having her enforcement experience and then moving into the diversion program is going to be a perfect fit because she understands the enforcement part of it. She also has experience creating trainings. She created trainings for the EU back in Europe years ago. So kind of a perfect person to take on that role. I want to say thanks to Suki and Ivy for filling in while we were without a head of our education group for a handful of months. And then also all the staff in education have been great to take up the role and fill in where needed. So thank you, Alex, Katie, Sylvia, Stephen, Adam. They really worked together to make sure all the work got done, even though they didn't have someone watching over them on a day-to-day basis. So on behalf of the commission and everyone here, we really appreciate their professionalism and the hard work that went into that. So that's the staffing updates. We should have something on the diversion program and what the plan is here in the next couple months to let the commission know. But we're just hiring now, and we're in the early stages of planning it and what it's going to look like. So other update I would give, if you remember back in, I think it was June, might have been May, we passed some regs to update our current regs in anticipation of CARS going into effect. Those regulations were passed contingent upon CARS being certified. Subsequently, we learned CARS was not going to be certified anytime soon. So what ended up happening is the regs ended up being published, but being contingent upon CARS being certified, which we thought would only be for a month or two. When it turned out it was longer than that, what we've done is withdraw those regs. Even though they were never in effect, they were in print. So we thought that would be confusing for people. So we've taken the step of withdrawing those regs so they will not be in print. We'll put back the old regs substantively in the same format. And then once CARS goes into effect, we will take these regs and send them back over, and then they will go into print. And and we can reconsider them at that time if we need to. So we just got word from OAL that that's in the works, so I just wanted to update the commission on that's what was going on. To be clear, the law has not changed at all during any of this time. It's just where it would appear. So we wanted to make sure it was clear to everybody what was the law that they should be following. Oh, you're leaning forward. Oh, okay. And then I was just going to mention real quickly to point out that we had another exemption request that we granted for a new Superior Court judge who had some privileged client dealings that were not get disclosed on a Form 700. With that, I'll submit the report.
Thank you, Mr. Bainbridge. Any questions or comments for Mr. Bainbridge? All right. Moving to the Admin and Technology Division report.
I would like just to submit the report as is.
Thank you, Ms. Hahn. Comments from Ms. Hahn? Hearing and seeing none. Last but not least, Executive Director West.
I have nothing to add today except for it's great news, everything that Dave reported on, and very happy on the progress that the legal division has made with the diversion program. And we do send out our condolences to the enforcement division that has lost two great people. So, but they're gonna hire great people. We know it.
Any questions or comments for Ms. West?
Just to say, I don't, with Executive Director West and Mr. Bainbridge, since they both came from enforcement, we'll have to take what you say with a grain of salt. So thank you.
All right. Moving to our final item, item 16. Sorry, is there any public comment on item 15 or executive staff?
Mr. Chairman?
Yes.
Mr. Chairman?
I'm here.
I have comment on 15, please.
Yes, please.
Public comment. Thank you very much. My name is Eugene Solomon. I live in Redondo Beach, California. I'd like to comment on the stipulated agreement between the Hometown Voter Guide and Michael Johnson. I wish the staff and commission to revisit this proposed fine for the Voter Guide and Michael Johnson, considering this. This organization followed a deliberate and calculated effort to conceal and mislead the public until after an election to avoid detection of the true sources of publication of the mailers and the financing. In contrast to the staff's finding in this case, there is undoubtedly harm to the public and an intent to conceal. The organization began collecting money 11 months before the election, but did not file any formation paperwork until after the election. The slate mailer organization didn't file any formation paperwork to allow for view by general public, but yet they collected money and sent out 3 citywide slate mailers in February of 2017 with deceptive wording such as Democrats Voter Guide or Republicans Voter Guide before finally filing their identifying paperwork 2 days after the March 7th election on March 9th. You can check their forms 400 and 401. The treasurer of this organization was a paid political consultant who was at one time chief of staff to an Orange County supervisor. There's no innocent error by an inexperienced candidate or committee. This is exactly what the FPP should be enforcing with the greatest of penalties, not the bare minimum of $400 per violation. The organization used a P.O. box or Redondo for return mail was actually based in Orange County. Paperwork filed after the election used a mail center in Orange County. The P.O. box mailing in Redondo was clearly an intent to deceive the public, the voter, to think it was a local group and not from outside the area. The organization listed $17,100 in contributions on their forms, but spent $5,000 more than that on the mailers. Where's the other $5,000? Why was it not revealed where the source was? In a news article about the source of the mailers, once it was revealed, one of the candidates, a mayoral candidate, stated, "I thought it was terrible. The mailers were so deceptive, and I believe they hurt my campaign." Unsure of who paid for the mailers, I asked around, but was unable to find out. There you have both concealment and harm to the public. For slate mailers known for being deceptive, these were especially egregious. I followed the money and found it was an LLC who gave money to a PAC that spent the exact money on the 3 mailers. The LLC's managing member was a developer who was suing Redondo Beach. I spoke with him at a meeting, and he revealed that, yes, he had indeed engaged Mr. Johnson. This was a clear intent to conceal the true source of the funding until after the election, so that it wasn't revealed that a developer who was suing the city was the source of the mailers and the money. I realize the staff is overworked and overwhelmed. I did all the legwork. I sent pages of details to staff in the email. All I had to do was look it up and verify. And 4.5 years later now, this intentional disconnect between public need to view these documents and the concealment of these documents results in a $1,200 fine. This will in no way deter bad actors in the future. So I kindly ask you to send it back to staff and ask for the maximum fines to be assessed for the failures briefly outlined above. I thank you very much for your time and your courtesy today.
Thank you. Appreciate your public comment. Any additional public comment on item 15? None. We will now proceed to item 16. Item 16, commissioner comments and proposed future agenda items. Do any commissioners wish to identify future items for our agenda? Baker?
You know, it's just for public transparency, when we receive I think this was this a streamlined matter that we just heard public comment about? If we don't, I mean, the streamline is I don't want to say out of the discretion of the commission, but can we get either from our enforcement or from the chair or Mr. Bainbridge, what kind of a primer on what are our resources? Because I don't think we have any say further in a streamlined matter, or.
That's right, we don't.
I just want to be transparent to the public about when something like that comes forward.
We've delegated, and we've discussed this at prior meetings, we've delegated this authority to the chief of enforcement, and there are regulations which I think very clearly go through what the extent of her authority is and what circumstances to streamline or would fall out of streamline. So that's our existing procedure. I imagine Chief Brereton will touch upon those procedures as part of her overview of enforcement processes in December, so we'll get more information at that time. Would like to just briefly remind everyone, though, that as much as I appreciate the public comment and the representations made there,
yes,
our staff, even with streamlined cases, reviews the information and conducts an investigation, and because of streamline, we are presented with the result, not the mainline stip. And so the information that we may be accustomed to seeing that give us confidence in those isn't presented in the same way in streamline because they're expedited. I just want to just make that point as well.
Good point.
But certainly if we have more questions about streamline, that would be appropriate.
Oh, that answers my comment/question. Thank you.
All right, Commissioner Wilson.
Kind of expanding on the comments by Commissioner Baker, I have the utmost confidence in our enforcement division and the outstanding work they do, whether it's a streamlined case or not. But whether it's the December meeting or some other forum, the public comment allegations, if you will, or statements were of a serious nature, and if appropriate, Chief Brereton or one of her staff should be afforded the opportunity to rebut those allegations. I'm sure that the work they did was right on point, but if someone just listens to this hearing, they may draw an unwarranted conclusion. I defer to you, Chair Matich.
Trying to require the chief of enforcement on delegated matters that have been resolved to a couple months later come and defend assertions that are made, by anybody without any background information or any verification. I think that might not be the best precedent for us.
It's ultimately your call. I just wanted to raise the issue. Thank you.
Right. Any other comments for future agenda items? Hearing and seeing none, I will make a motion to adjourn. Do I have a second?
Second.
Baker?
Commissioner Baker?
Aye.
Commissioner Cardenas?
Happy Thanksgiving, yes.
Happy Thanksgiving. Good point.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you, and as Commissioner Cardenas said, happy Thanksgiving to everyone. We'll see you next month. All right, take care.